Carry. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Thank you for that rousing cry. Good morning, everybody, and welcome to the first sitting of the Appeals Court for the 2023-2024 term. Your panel today is me, Justice Massing. To my right is Justice Grant. To my left is Justice Brennan. As fresh reminder, if anybody hasn't been here before, 15 minutes per side, no rebuttal. We have read your materials, so you don't have to give us a lengthy introduction. You can just jump right into your arguments. We have, in fact, the materials are these days. We have them on our tablets next to us. So if you see us scrolling through our tablets, we're not looking at sports or surfing the web. We're actually looking at the record. And as I said, you have 15 minutes, but there's no penalty for finishing early. So with that, we'll call the first case for this morning, which is Commonwealth v. Hempel, 22P913.
Good morning, Justices. Dana Goldblatt for Mr. Hempel. It's an honor to open your session. This is a case involving a appeal.
Attorney Goldblatt, could you pull your mic a little bit closer to you? I can't quite.
Is that better?
Let's hear you.
Testing.
Yeah, I think that's better.
Okay.
Thanks.
This is a stay of execution of sentence case. Stay of execution was denied before by the single justice, and here we are. The standard is reasonable possibility of successful decision. That's the first prong we have to reach, and that's what I'm going to start with, unless anyone prefers to skip that and go straight to likelihood of flight or future criminality. Mr. Hempel examined a witness and made his own closing argument. In so doing, he was acting pro se, without counsel. He was not given the kind of colloquy that we expect to see when somebody is about to take over the handling of their own case. And there's nothing in the record that suggests that he had any sense of the magnitude of what was happening. In fact,
so you say the Mitchell protocol is not appropriate because different interests are involved here. What is the model that the judge should be following?
The model that the judge should be following is Commonwealth versus Miranda, which is cited in my papers. That case delineates the role of counsel as opposed to the role of a criminal defendant. And a criminal defendant decides whether to plead guilty, waive jury, testify in his own behalf, or forego an appeal. Now, when any one of those issues is before the court or is in play, the defendant has certain rights.
But this was a situation where the lawyer, defense attorney, said that he did not feel comfortable examining the witness that the defendant wanted him to call.
That's accurate.
Miranda and Mitchell are situations about the defendant taking the stand and the lawyer having reason to believe that the defendant might commit perjury. Do you have a case that says that a defendant has a Sixth Amendment or any other right to require a lawyer to call a witness that the lawyer believes is going to commit perjury?
No, in fact, he does not have that right. That's what Miranda is saying. He has the right to testify, but he does not have the right to pick his witnesses. And
so I understand that your contention then would be that the better practice would be to simply allow the lawyer to tell the client we're not calling that witness.
Exactly. That's not only the better practice, it's the necessary practice.
And why wasn't Judge Nickerson's approach, extrapolating from Mitchell, a better approach in terms of at least allowing the defendant to have a more fulsome defense from his perspective?
In answer to that, I'm going to read from Gonzalez versus United States, which is not cited in my papers. I'm going to give the citation now, 553 U.S. 242.
Sorry, do that again?
Gonzalez versus U.S., 553 U.S. 242.
Okay.
I think it provides the perfect answer to that question. Numerous choices affecting conduct of the trial, including the objections to make, witnesses to call, and the arguments to advance, depend not only upon what is permissible under the rules, but also upon tactical considerations and the larger strategic plan for the trial. These matters can be difficult to explain to a layperson, and to require in all instances that they be approved by the client could risk compromising the efficiencies and fairness of the trial process. Beyond that, a situation in which a defendant has some kind of Sixth Amendment right to choose his own witnesses without proceeding pro se would be very, very chaotic. We have a very...
What if the defense attorney said, out of the presence of the judge or the prosecutor, what if the defense attorney said to the client, look, I'm not going to call this witness. I'm not going to examine them. You can call him if you want, and I'm not going to argue anything this witness testifies from in closing. So if you want those points to be made in closing, you've got to make them. What would be wrong with that, and how do we know that didn't happen?
First of all, it wouldn't be wrong if the court wanted to do that. The court certainly can.
No, I'm talking about the defense attorney.
The defense attorney can certainly ask the court to let that happen. But
wouldn't that be the judge intruding into the attorney-client relationship?
No.
You're saying that the defense attorney should ask the judge before he or she has a conversation with the client?
No, not before having the conversation with the client. So the conversation would be, do you want to examine a witness? The client says yes. Now, in order to let the client speak at the trial, except to testify, they need to get permission from the court. So the lawyer would then have to go to the court and say, my client wants to examine a witness, we're seeking permission. The court has discretion to deny that because the client has no Sixth Amendment right to waive counsel in increments. So there's no right to do it. The client has no right to ask for that, but as with all things trial management, the court can in its discretion grant it. If the court grants the right to proceed pro se in segmented units like that, the defendant is entitled to know the scope of what he's doing.
So let me ask you, and when you read the transcript, it's pretty evident that the judge and the defendant had a familiar relationship on some level, right?
Yes.
And fair to say sometimes when you go into a formal colloquy, if you've sat next to a client, sometimes they just tick off yes, 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 no, no, no. Why wasn't it better for the judge to engage the defendant here, have a more human conversation, explain things in less formal terms? Why was that not a better way to get the point across and to make sure that the defendant understood what was happening, as opposed to just checking the boxes on a formal colloquy?
I think that would be great. I think giving a warning in language that a client can understand is fantastic, and there would be no problem with that. What happened in this case was the opposite. The client was explaining why he did not want to take over the case, and the judge, in very homey and understandable language, was encouraging him to do it anyway. When the client asked about sentencing exposure, the judge said, let me worry about that if you get convicted. When the client said, I only have a GED and he's law trained, the judge said, well, you're smarter than a lot of lawyers I see in my courtroom anyway. So yes, a homey warning is good, but that's not a warning, that's encouragement. And in this case, it's clear as you're reading that transcript that what's going on is there's a real breakdown between the defendant and his attorney. And the judge has decided on an outcome that would solve this problem and move the trial forward, and is encouraging that in his mannerisms, in his speech, in the way he talks to the defendant. And the defendant is deferring to that authority, which is what he should do. When the judge is signaling what should happen, he's very much agreeing and going along with that.
Okay, Attorney Glover, I think we get the point, and I do want to ask you about the second prong. So you don't have to win this right now, right? Because all you have to do is establish that this is an argument of some heft, right?
Yes, Judge.
But you do have to win the security issues. And I wanted to let you get off on the right foot, but I have a bone to pick with you. On page 23 of your brief,
Yes.
you say, first and perhaps most significantly, the trial judge in this case set bail before trial. That means there had been a finding that there are conditions that would reasonably assure the safety of the community. 2 pages before that in the transcript, the judge held the defendant on dangerousness. Right? Did you miss that?
There was a holding in dangerousness, but there had been a bail set earlier.
No.
I saw that in
No,
the docket.
no. Your client was found was detained for dangerousness under 58A, and then bail was set because the time that you're allowed to detain somebody for had expired. And if you read the transcript, when bail is set, the judge says, you've reached the 120 days, I have to issue bail. So there actually was a finding of dangerousness in this case.
And wasn't the bail $500,000?
The bail was high, yes. And the finding of, my understanding is that and I've certainly seen this multiple times in my cases in Superior Court, that dangerousness can be continually revisited. That it's not that after 120 days, they have to set a bail. There's repeated findings of dangerousness that are made. So the fact that a bail was set.
That's not what happened in this case, though. The judge never found that your client was not dangerous. The judge said, I think I'm required by the statute to set bail at this point.
Well, that, I think, was a misunderstanding of how the dangerousness statute works, but yes, bail was set at $500,000.
But I don't think you can, even that's a misunderstanding, I don't think you can get that the judge found that he wasn't a danger.
I think you're right then. The judge just misunderstood the statute.
But $500,000 bail.
And made $500,000 bail. And certainly in this case.
And your client didn't meet bail, right?
No, he never made bail. He stayed in jail the whole time.
Okay.
So my understanding of Mr. Hempel's situation was that the bail and the dangerousness were based on the charges that he was facing and their seriousness and the allegations that had happened. The evidence that has since been produced by sending the items to the lab, which Mr. Hempel was consistently pushing for from the moment of his arrest, tends to undermine those charges.
You're not suggesting that the 18 restraining orders were not a factor in the dangerousness determination?
I think the 18 restraining orders were. I also think that the 18 restraining orders misstate Mr. Hempel's dangerousness because of the issue of the custody dispute that so many of them were involved in. He has a history of drinking, and when he drinks, he gets into fights. What people say is he's not the first aggressor, but he does get involved in fights. That doesn't mean he's so dangerous that no conditions of release would satisfy the court. The main issue for dangerousness was this allegation that he had shown up with an axe and was chasing people around, which he denied. There is now evidence, although it's not proof of innocence, there is strong forensic evidence that that didn't happen. And when you put that evidence in as part of a dangerousness assessment, as opposed to, it wouldn't be appropriate in bail, but it would be in a dangerousness assessment.
Can you just identify what that evidence is?
Yes, that's the evidence that is in part the basis for the Rule 30 that's pending now. Mr. Hempel, the background on it was that he had been asking for the axe to be tested because he said, I never touched it and it never hit anybody. I was there, they hit me with it, I puked and passed out because I was so drunk, and that was it. And if you test the axe, it'll prove it. And the axe never got tested, largely
Until after
the
when
trial.
unfortunately the clerk touched it, the lawyers touched it.
Yeah, so there might be a lot of additional DNA on the axe, but the absence of blood, it's not the case that just touching something is going to wipe blood off of it. There's pores in it, the blood gets down. They didn't find any blood even on the reddish stains, and there's no touch DNA by Mr. Hempel. Now, that might be equivocal because the testing took so long to get. But it is evidence in his favor, and it does tend to undermine the dangerousness argument, especially because he was saying from the beginning to his attorney, and in court repeatedly, that I'm waiting for testing, we're waiting for testing. He thought it was being tested, and that was a miscommunication with his attorney. He only found out right before trial that it wasn't being tested and hadn't been. So this is something he's been maintaining from the beginning. And when it was tested, it did show what he said. So he was asking for it to be tested early on. He just couldn't make that happen because he did not have, I think, good communication with this attorney. And in his defense, he asked that the attorney be removed because he didn't have good communication with the attorney. That was earlier than this issue with the witness.
So you first moved for a stay in the Superior Court, it's pending and never ruled upon, right?
I think that's right. I think we had to,
Yeah.
yeah, I think it was never ruled on.
I think there's no, I think, yeah, so when it came up here to the single justice, what was the status of the DNA testing?
I think when it first hit the single justice, the DNA testing had come back. By the time we got to the single justice, it had come back.
Okay.
Because it was part of because we'd already filed the Rule 30, and I think the Rule 30 was part of the evidence before the single justice. I don't have 100% recall on that, and if I'm wrong, opposing counsel will correct that. But I think that's the order.
And what's the status of the motion for new trial now?
It's been argued, and it's now under advisement. And has been for some time, I think, over a month.
Okay, that's not too bad. All right, well, if you have nothing else, we'll hear from the Commonwealth.
I have nothing further. If you have no other questions, I'll finish early.
Thank you.
Thank you, Justice.
Good morning. May it please the Court. Elizabeth Sweeney on behalf of the Commonwealth. Prior to addressing the substantive argument, I'd just like to make 2 points. The defendant's motion for new trial was argued on 7/28 before Judge Callan. I checked yesterday. It's still under advisement. And in addition, there is a pending appeal on the defendant's conviction and that motion for new trial that is stayed pending that decision. I'd also like to note that in the motion for new trial, there was an affidavit filed with the defendant's brief by defense counsel. The timing of this motion to stay sentence and that motion for new trial filing differed by, I want to say, 6 months. So that affidavit by defense counsel is not in this record, but I would be happy to supplement the record if necessary. Turning to the substantive
So what would the affidavit tell us?
The affidavit basically says that the communication fell out between defense counsel and the defendant. It talked about how the defendant wanted to call Karen Kane. It doesn't get into the substantive decision-making in their conversations, but it's just an affidavit from defense counsel, and I thought it would be prudent to mention for this court. The single justice of the appeals court, Chief Justice Green, did not abuse his discretion in denying the defendant's motion to stay sentence. And this court is familiar with the two-pronged test. I'm not going to belabor it, but the defendant has not shown a presentation of an issue to the appeals court with some reasonable possibility of success, and the defendant certainly has not established that he has no possibility of flight. The defendant is a potential danger to any person based on the egregious and disturbing facts of this case. The defendant is serving a 20 to 22-year state prison sentence for armed home invasion. The defendant is framing the issue of representation as a colloquy issue, and the Commonwealth strongly disagrees. That is not the issue here. There is no colloquy issue. The right to testify and the right to an attorney do not extend its protection to perjury. And there's several cases on point. The court asked defense counsel that during argument, and I'd like to note Nix v. Whiteside. I believe that's mentioned in my brief. Also, I believe this is the third time we've argued this issue substantively. The argument has developed, and there's 3 other cases on point. Commonwealth v. Waiver, that is 484 Mass 766, a 2020 SJC case. Also,
You didn't file a Mass Rule of Appellate Procedure 16L letter on Leyva, did you?
I did not file a 16L
Okay,
letter.
it would have been helpful.
Next time I will apologize. Thank you.
I knew about it.
We did argue Leyva at the motion for new trial argument as that issue. This issue has kind of developed over the course of years. It's the third time we've argued it. And the court on that date did have questions about the requirement of a colloquy. And it is the Commonwealth's position that the defendant's exercise of his right to counsel doesn't secure representation outside the rules of professional conduct.
What if there was a situation where the defendant wanted, this is hypothetical, the defendant wanted counsel to call a witness, and counsel believed that the witness was going to lie, but the defendant said, no, it's the truth? At what point would the judge need to become involved in determining the level of certainty that the lawyer has that the witness is committing perjury?
So I'd referred this court to Mitchell and also Leyva in the ethics rules 3.3a, e, and 3.3e. The court essentially takes defense counsel's representation that there is an issue at face value and is not necessarily required to inquire. Judge Nickerson did note that in the transcript. I believe it's volume 2, pages 17 through 21. That's the substantive discussion, and that's in the Commonwealth Supplemental Appendix. And the court, Judge Nickerson, did note in this case, once there is that representation, I'm not going to necessarily inquire of it because we have to be cognizant of defense counsel's role as an advocate for their client and also them recognizing the rules of ethics procedure.
Granted, it was a pretty creative approach, but, so you're not aware of, because I'm not, of any other situation where a judge has permitted this sort of incremental, well, you can represent him for this, but not for this, and then we'll kind of try and smooth it out so the jury doesn't quite get how bad it is, what's going on here. I mean, I'm clearly paraphrasing, but you get my drift?
There's very limited Massachusetts case law on this issue, admittedly. There's Mitchell and there's Lieva. There's significant United States Supreme Court opinions discussing the role of defense counsel and their ethical obligations. But here, I would suggest that Judge Nickerson almost in a, this case was before Lieva, he complied with that procedure in this somewhat hybrid, you're going to represent yourself or during the potential perjury questions and also closing argument. I'd note that Lieva does say that the defendant needs to be informed of his right to counsel, which the defendant was here on supplemental appendix pages 17, 21, and 31. And the defendant was informed of his attorney's ethical obligation to not place false testimony before the court. That's volume 2, 17 through 18. And then also noted counsel's invocation of the rule, and that was in the letter that defense counsel noted that he gave to his client. I can represent you, but I cannot put perjury before the court. So I think in this situation, Judge Nickerson's conversation with the defendant, as this court described it, was very colloquial. It was a conversation. Notes that this defendant has had 4 attorneys. The record reflects that the defendant did have some difficulty with his prior attorneys, and where this situation was somewhat sensitive and touched upon defense counsel's ethics issues, I believe that he did handle it in the correct manner under Massachusetts and also United States Supreme Court opinions. If there are no...
So, I mean, would you say that, I mean, the standard is pretty low, isn't it, on the first prong?
Yes.
An appeal which presents an issue that is worthy of presentation in appellate court, one which offers some reasonable possibility of success? Does that not describe this issue?
It's the Commonwealth's position very strongly that that does not describe this issue because Lieva and the United States Supreme Court opinions that I cite in my brief do address this situation. And in addition, the defendant was represented by counsel during the opening, during jury impanelment, during cross-examination of the Commonwealth's witnesses. And I'd also like to note that Lieva notes that if the defendant intends to submit perjury to the court, the relinquishment of this right does not leave the defendant unrepresented. It's a rule-based relinquishment, and that's exactly what happened here. So I don't believe that this is a novel issue. While Lieva and Mitchell did deal with a defendant who wanted to testify before the court and essentially perjure themselves, that same rule should apply when a defense attorney is faced with a situation where the defendant intends to submit perjury before the court. And Volume 2, Supplemental Appendix, pages 20 to 21, do note a conversation where the defendant insisted on putting this information before the court. So I'd suggest that it's actually very similar to Lieva and Mitchell with the specific ethics rules that we're dealing with. Turning to the DNA issue, I would just like to note briefly that on April, I believe it was April 8th of 2022, I know it was the first week of April, we had an evidentiary hearing. There were 3 witnesses for the Commonwealth. There was Dorothea Collins from the Crime Lab, who was the former head of the CODIS unit, and also Amy Barber, who was the technical leader, and Orleans Police Officer Chris Yurkowski, who was head of the evidence room and observed the testing of the axe by the defendant's expert. The court heard testimony that the axe was touched by jurors. The axe was passed around and it was given to the jury. The defense attorney wanted them to look at it and to touch it. The axe was stored in the clerk's office in a outside of a manila envelope with a rubber band wrapped around it with 2 knives that were found on the defendant tucked inside that envelope. So while it wasn't a secure facility, it was not stored in a secure manner. And Ms. Barber did testify, and Judge Gilday noted in the denial of the 278A motion, the second 278A motion, that the DNA, she noted that it was, handled by so many people, so there would be, smudging, wiping, and somewhat degrading. And Judge Gilday did rely on that when he denied the 278A. So I suggest that there is no DNA issue that is worthy of presentation for an appellate court. Turning to the last issue.
So you're saying that the results of the DNA test don't undermine the crime or the dangerousness of the crime?
They do not. In fact, the acts, I neglected to mention, there was 4 swabs taken. Only one of those 4 swabs was tested. Also, the serology report, which I put in my supplemental appendix, I believe it's also in the record appendix, Bodie noted that they cannot say for certain that there is no blood for the presumptive testing. They just said it's below their level of testing. And Judge Nickerson and Judge Gilday did rely on that when denying the 278A motion, the second one last year. I'd also...
I take it, I haven't read the transcript, that 4 witnesses testified that the defendant came in wielding an axe? Is that?
There were 3 witnesses that testified, It was Matthew Kane, Susan Kane, and Kevin Eldridge, her husband, and they testified that the defendant broke down the door, and this ties to my second argument. The defendant broke down the door and went in the house swinging an axe over his head. He cut Susan. She had to go to the hospital for 9 stitches. The Commonwealth introduced the back of her pant leg. That was sliced completely down the back, and her shoulder was cut. She needed stitches there. The 2 individuals, the 2 males on scene, wrestled the defendant to the ground, removed the axe from him. They called police. The defendant had 2 knives that I mentioned earlier that were tucked in that envelope in the clerk's office that popped out from his shirt, and the police arrived as Ms. Kane, Karen Kane, the defendant's witness, ran to a car, went to the Orleans Police Department and told everybody that Jamie was inside killing everyone. And I did supplement the record. I included a copy of the audio CD of Ms. Kane's statement she made that day at Orleans Police Department with Detective Melissa Marshall as part of the Commonwealth's appendix. And that was, she was cross-examined with those statements at trial. Addressing dangerousness, though, I'd just like to note that the victim's house in this case is 1.3 miles away from where the defendant is requesting to live. The defendant, in his argument, relies on an affidavit by his son claiming that he's not dangerous. The Commonwealth included a police report where that day the defendant's son made statements about how the defendant went to his house and told him that he was angry at Karen for what she's done. He said some incredibly offensive words and said he had an axe and he was going to do something about this. And now we have this set of facts here that we're arguing today. The defendant was held on dangerousness, as I noted in my brief, $500,000 bail. And I suggest that the defendant cannot meet the second prong where he's serving 20 to 22 years for armed home invasion. The victim, Ms. Kane, that day had attempted to obtain a restraining order. If you review her cross-examination by the Commonwealth, we use that affidavit to cross-examine her. The defendant was not served. So if the defendant cannot abide by an attempted to be served restraining order, then I suggest that there are no conditions that can keep him safe, especially in light of him serving the sentence in state prison. There are no further questions. I rest on my brief.
Seeing none.
Thank you.
Thank you both. Excellent arguments. I think the court year is off to a good start. We'll, of course, the case is submitted. So the next case will be Commonwealth versus West, 22P195.
May it please the court, Edward O'Brien appearing for Corey West. On the issue of whether bad acts, modus operandi evidence can be used to rebut the defense of fabrication, I have to confess that I did not find any case that was on point in sexual assault cases. The closest I've come to are cases where prior bad acts of the defendant are admitted to explain why a victim delayed in coming forward and disclosing the rape.
Counsel, can I kind of, to me, cut to the chase on this, which is, can you point to anywhere in the transcript where Judge Chin actually made a ruling that the evidence would be admitted? I mean, he says it may be admissible to counter the claim.
Well,
I might reconsider it. Best I can tell, that's not an actual ruling, though, is it? Or is it somewhere that I missed that he actually made a ruling
well, we're looking
on that
at,
issue?
at Volume 2 in the around page 176, 177.
Okay.
And I would say that the judge has actually indicated quite strongly what he intended to do. On page, I think...
Can I just stop you on 176? I know you are not making a ruling at this point, Judge. That's from one of the attorneys. And then, et cetera, et cetera. And then the judge doesn't say, well, no, in fact, I am making a ruling. They sort of talk around the issue.
The judge had stated before then that the Commonwealth is entitled to rebut the defense claim here by that evidence that was previously excluded.
So again, can you point to the record where it is? Because again, I saw some mays, and maybe I might,
Yeah,
but I didn't see an is, or will, or any other word that might at least suggest to me that it is an actual affirmative decision or ruling on that issue by a trial judge.
On page 177, Your Honor,
Okay.
line 1 and 2, the court, after saying it's not a simple question, it's the crux of the defense, court states, it comes in as a false allegation of rape to which the Commonwealth has a right to counter. And so the defense counsel is hearing this, and even though the trial judge says, hey, you know, it's up to you, the evidence...
Just hold on, though, but then, just not to interrupt, but then he says, I guess that's the ruling as far as the prior false allegation, and then he says, and then I will explore whether or not the Commonwealth can put in the prior act in Suffolk. It seems equivocal. I'm not suggesting for a moment that Judge Chin isn't giving a few signals there.
Where you have such inflammatory evidence that the court had considered and excluded. I mean,
Why are you saying it was admissible? Are you saying it was admissible as a prior inconsistent statement or a false allegation?
both, Your Honor.
What evidence is there in the record that either that she said this
Right.
or that it was false?
Well, the whole debate and issue is triggered on cross-examination of LC. I'll call her the complainant LC in my brief. When defense counsel is taking her through her...
But on voir dire, she denies that she said it.
What she said was on cross-examination was that in the trip down to Fall River, her customer never showed up.
Right. And then they have a voir dire outside the presence of the jury.
And then they get the voir dire.
And she says he did show up, he was skeevy, so I left.
The offer of proof is that one of her so-called friends, Hopkins, testified at the grand jury that
Right.
she had come back from that meeting and said, I've been raped.
So counsel, based on the grand jury minutes, would have had a good faith basis to ask the victim when the jury returned to the room, did you say this to Hopkins and DePina? Did counsel ever ask her that?
At the trial, Your Honor?
Right.
Well, when Hopkins did testify,
No, when, after the victim's voir dire, when the cross
Yes.
continued, did defense counsel ever ask her, did you say, in front of the jury, did you say this to Hopkins?
no. No, I think counsel wanted to steer quite clear of that.
And so then when Hopkins testified on cross-examination of Hopkins,
Right.
did defense counsel ever ask, did she say anything about what the guy in Fall River did to her?
No, he steered clear of that issue
So-
for fear that,
What evidence do we have in the record that she made the statement?
well, her statement was on cross-examination that her customer did not show up. That was the statement. And so the evidence that she claimed that she was raped by the customer rebuts that.
Where is that evidence in the record, though? If defense counsel never elicited it on
well-
cross, do we have the grand jury minutes in the record?
Well, no, absolutely not, Your Honor. I mean, consider the position that defense counsel has been put in by this judge. If he breaches it, if he goes near that territory in his examination of these witnesses, he runs the risk of the Commonwealth having another a prostitute who is the alleged victim in the Suffolk case come forward and completely sink his case.
So let me ask you this. So isn't that the risk you run in terms of developing a trial strategy? And are you suggesting that that was patently inadmissible? And because it seems to me that there are a lot of trial judges who might well have said, that's pretty good MO. Same exact, the back page, the knife, the same sexual acts. I mean, talk about identical
4
MO.
months before?
Well, what we have is a ruling already by the trial judge.
But assume we say that ruling, he could make the ruling, but it's not, would it be an abuse of discretion if he had gone the other way?
But he's kept it out. He's kept it out on a couple of grounds. One, it's not an identity case. There's a discussion of modus operandi. Two, he's determined that the prejudice is so inflammatory, he's going to keep that out. And I say that those two issues are not connected.
But if
Well,
that's, so sorry, go ahead.
what about the identity issue? If the defendant is going to argue it was the guy in Fall River who raped her, not my client?
Well, only insofar as it may explain bruises on her neck or the
Did the
redness
defendant
in-
file a motion to eliminate to admit rape shield evidence?
That was not brought in, Your Honor. The two issues are separate. And they're not related. I was checking last night to see if I had missed anything recently. Nothing in sexual assault cases, but there was a case the SJC decided in 2017, Commonwealth versus Denton, 477 Mass 248. It's a narcotics case, possession of heroin, and the defendant raised the defense of entrapment. And the SJC said that the Commonwealth was entitled to refute that affirmative defense by evidence of the defendant's prior narcotics convictions. In that particular case, they said that the convictions were stale and overruled it. But here, what distinguishes this case from the Denton case is that was part of the affirmative defense, is the state of mind of the defendant. Here, it's entirely different. You have two separate issues. You have prior bad acts evidence, which has been excluded as inflammatory irrelevant. You have, on the other hand, a prior false allegation of rape. And I would say that the defense counsel preserved the claim of constitutional error here. It's clear from that discussion where the judge is heading, and it's too risky for a defense counsel to take the chance to go near that area, because if that evidence comes in, the Commonwealth calls this prostitute from the Suffolk case, Mr. West is sunk completely in front of this
You have a
jury.
case that says that telling someone telling their friend that as opposed to reporting to an emergency room or to the police, telling their friend, I was raped, is a false allegation within the meaning of Bohannon?
Well, there has to be, first of all, a good faith basis from a third party, and it fulfills it here. There's been certain cases about patterns, but see, the pattern here is I see it. I mean, it's not directly in the record, but there's inferences from the evidence that these two so-called friends of LC, there's DePina, who took the fifth, he didn't testify, and DePina walked away from the police officer at Brockton when he was approached, and Hopkins is DePina's roommate. And these two so-called friends are driving LC around Friday night into Saturday morning. They're going from Plymouth to Brockton, to Fall River to Brockton, so that she can service her John clientele. I suggest there's more than enough inference for a jury to conclude that these two are more than friends. They are her pimps, and they are her muscle. And therefore, when she comes back...
But she denied that, and Hopkins denied that.
She can deny it, but a denial is not evidence. There's plenty of inference for a jury to conclude
So
that...
if a denial's not evidence, how's a denial inference?
The inference here is when she comes back, now this is twice, the same night, I've been raped. Well, there's no money. There's no money to pay DePina and Hopkins for their services for the night, which gives her an incentive to fabricate this allegation.
Counsel, can I ask you, why is the denial not evidence? If she's asked, is he your pimp? And she says, no, it seems to me that's evidence, testimonial, that he's not her pimp. And if he's asked, are you her pimp? And he says, no, seems to me that's evidence. The jury can accept it or reject it like any other piece of evidence, but why is it not evidence?
It's not determinative, like you said, Your Honor, the jury can, but when I'm saying separate and apart from the denial, I mean, the defendants get on the stand and deny it. It's certainly not binding on a fact line.
No, but it's certainly evidence.
And are there inferences from this evidence that gives her a motive to lie? And that motive to lie, you're talking about constitutional deprivation of the right of this defendant to have a full defense.
So assume for the moment we follow your argument out, and it is argued that that's her motive to lie and that there's some suggestion that she's fabricated this. Why would the judge then have been legally wrong, or why would it have been an abuse of that judge's discretion to say, now in this context, I suppose the Commonwealth should be able to show that this same exact circumstance happened to some other person, allegedly, 4 months earlier?
All right.
What's wrong with that? I mean, it's certainly within, I understand it's extremely prejudicial, but why couldn't a judge then say, but the probative value in this context is so high that I'm now reconsidering my decision, I'm going to let them have it?
Well, I'm going to say there is no probative value and no connection between the two. The defense that this wasn't happening, that was the defense from the time that this started. There was a DNA match. Well, Mr. West fit the major profile in the DNA sample found on LC. And so the defense is put forward, well, this is a customer. This is, he is a customer of her sexual service, and that no rape occurred. And so by definition, it's a fabrication defense. And given that, the trial judge said, no, it's not relevant, and even if it was, it's too unfairly prejudicial and inflammatory for the jury to consider. Those two issues are separate. They're not linked, like the Denton case where the affirmative defense is so
What about the aggravated portion of the aggravated rape on which your client was acquitted? If the prior bad act had come in, that your client similarly used a knife 4 months before on the woman in Boston,
Yes.
Wouldn't that have helped the Commonwealth to corroborate that element of aggravated rape?
Well, no. I'm saying that they're not related. It would have been unfairly prejudicial and inflammatory. And
That's different from not relevant. That's different from not relevant. If inflammatory and prejudicial, maybe, but why is it not relevant?
It's not relevant because whether the LC had a motive to lie or had prior false allegation of rape, and the prior bad act of what might have happened in Suffolk several months earlier are not connected. They're not connected evidentially, and that's why it's an error. And so I would just conclude that the defense counsel preserved the issue. He said, "You're foreclosing my right to inquire." He didn't cite the Sixth Amendment, Article 12 specifically, but he preserved the constitutional error, which I submit the Commonwealth has to show was harmless beyond a reasonable doubt. Thank you.
Thank you. We'll hear from the Commonwealth.
Good morning. May it please the court. Johanna Black on behalf of the Commonwealth. So first, I'd just like to reiterate some of the reasons or some of the evidence that the judge did not, in fact, make a ruling saying that he would definitively admit the prior bad act. Specifically, and I know Justice Brennan went over some of the portions of the transcript that shows there was no definitive ruling, but specifically, in the final pretrial conference, in denying the Commonwealth's motion in limine to admit that evidence, the judge did note and only note that there is a possibility that if the defendant were to open the door to that evidence, then he would consider admitting it, which is not a hard and fast ruling that he would allow it. Then, in the second transcript, at one point he says that he hasn't decided yet regarding whether the prior bad act evidence is coming in, and that's on page 175. On page 176, as Justice Brennan pointed out, the defense attorney himself says he understood that the defendant had not made a ruling on whether the prior bad acts would be admitted. And then my sister also quoted in her brief the fact that the judge was saying that he would explore after he essentially gave the defendant a benefit to which the defendant was not entitled under the law, i.e. Allowing in the prior allegedly false allegation of rape, assuming the defendant were to lay the foundation in evidence. After he gave the defendant that benefit that he wasn't entitled to in the law, as my sister laid out in the brief, the judge said, "I will explore at that point the evidence the Commonwealth is seeking to use to rebut the defense's theory of fabrication." He didn't say he would allow it in. And moving on to that, my sister did a pretty good job, and I'll rest on the brief where she explains it, but the Commonwealth is entitled to rebut a defense's theory at trial. I mean, there's a reason for rebuttal evidence, and case law does show that when a defendant attacks a victim on the stand under an exception to the rape shield law, the Commonwealth is entitled to rebut it. And that's all the judge was saying at trial when he said, "I'm not going to let you prevent the Commonwealth from responding to your defense." But he didn't make a ruling on how he would allow the Commonwealth to do that.
Is rehabilitating a witness a reason for allowing a prior bad act under, Section 404B2? It's not motive intent.
It's not in, I can't, I'll say, off the top of my head, I don't recall 404B saying that in the guide to evidence. However, there is case law that shows it is. For example, my sister quoted Commonwealth versus, I think it's Facella, F-A-C-E-L-L-A, which is an SJC case from 2017. And in that, the Facella had claimed that he murdered the victim because he was on a particular drug. And the Commonwealth was allowed at trial, and the SJC upheld the convictions, to rebut that theory by presenting evidence of two other relationships where Facella had beaten two other women he was in relationships with, similarly to how he had beaten and ultimately murdered the victim in the Facella SJC case. And the courts found that proper to rebut the defendant's claim that the drug is what made him beat and kill the victim in the case at bar. Essentially, the Commonwealth used the two other incidents, I believe one was a plea, entered through a prosecutor, and then another victim of Facella's had testified to the other incident. So there were two incidents, and those two incidents that the Commonwealth was using as rebuttal evidence had occurred at a time when Facella was not on the drug. And so the trial court and the SJC in that case said that although very similar in acts, very similar prior bad act evidence to the incident that was at trial, the SJC said that the Commonwealth was allowed to do that because it showed that it wasn't the drug, as the defendant had claimed, that was causing him to kill, because he had beaten other people in the same way when he had not been on the drug. And I'm just forgetting where I was about to say here.
Maybe I can help you out by asking a question.
Sure, thank you.
Even if the judge did not make a definitive ruling on this issue, why should we not analyze it as if a ruling was made? For all intents and purposes, given the dynamic of that trial, in terms of the defendant's decision-making process, right? Didn't he intimate a ruling sufficiently that it would have impacted the defendant's ability to present a defense on some material level? It's an awfully long question.
No, I understand what you're asking. So if we were to assume that everyone understood the judge's comments as indicating he was going to ultimately allow the prior bad act evidence, I think it's then on the defendant to make a strategic decision as to how he wants to conduct his defense. The judge wasn't stripping him of a defense. To the contrary, he was allowing the defendant to admit evidence pertaining to his defense, that being that the victim was essentially lying in this case to avoid paying her two male friends, who the defendant was trying to claim were her pimps or muscles. And all the judge was really doing was essentially warning the defendant, I'm not going to prevent the Commonwealth from rebutting your defense. That's what they're entitled to under the law, both under rape shield case law and then other case law as well. And I think a defendant being informed of the possibilities that can happen at a trial then makes a decision as to what he or she wants to do. It's not that the judge said you're not allowed to admit the evidence you want. It's just you can't have a one-sided trial. It has to be a fair trial, both to the Commonwealth and to the defendant.
What would be your best argument if you were making it, and perhaps the trial prosecutor made it, as to why independently that other Suffolk County conduct should have come in this trial?
The best argument?
Yeah. It may be sort of what Justice Massing already asked you, but I'm not sure, so.
So I believe, if I remember the Anastal case correctly, I believe my sister did cite a case specifically pertaining to similar circumstances where it was a sexual assault case, and I'm sorry, but I think the cases are jumbling, and I can't remember if Anastal is it specifically, but Facella, I think, does a really good job. Even though it's not right on point, it's not a sexual assault case, it does a good job of supporting the Commonwealth's position and the judge's position that we are allowed to admit prior bad acts in rebuttal of defense theory. And I know that there are cases out there, and I believe at least one was cited in the Commonwealth's brief, that talk about in sexual assault cases, when there's an exception to rape shield statute and a defendant is allowed to get in a theory of fabrication, the Commonwealth's entitled to rebut it.
What about the Commonwealth's case in chief? That's what I'm saying, that essentially the argument that the judge in the motion in limine got it wrong, and that the evidence could have been and perhaps should have been admitted regardless. Do you have any?
So it's interesting too, the word modus operandi was used a lot in the motion in limine, and I know that technically speaking in the legal realm, that is usually used to refer to cases where identity is at issue. However, the common definition of modus operandi is pattern or pattern of conduct, and really that's what we're talking about here. The reason prior bad acts are allowed in these types of circumstances to rebut a theory of fabrication is because they're so similar. And my brother cites to McGuire and maybe another prior conviction case to argue that because the prior bad act was so similar, it should not have come in, but that's actually, that case and any other prior conviction case is an opposite to what we're dealing with here, because when it's a theory of fabrication, the more similar the prior bad act is, sometimes the more probative it is, and there's a case that I remember reading in preparation for today's argument that said, in fact, the more similar the prior bad act is to the charged crime, the longer the time frame may be. Getting back to what you were saying, I want to also point out that when you're just talking about rehabilitation, there's also case law that shows when a witness is attacked under a bias challenge, so like the cross-examiner is trying to put forth evidence that the witness is biased or has recently contrived their testimony, the Commonwealth, that's kind of a rare case where the Commonwealth is entitled to use a prior consistent statement. So the case law supports, general case law supports the notion that the Commonwealth is entitled to rebut. And in terms of using specific prior bad act cases, my sister in her brief cited to cases that support prior bad acts specifically being used to rehabilitate a witness.
What do you, you're using the words pattern of conduct, reminded me that trial counsel argued that the victim's statements in Fall River were admissible to show that she had a pattern of making allegations to DePina and Hopkins. What do you, if the prior bad act is admissible to show the defendant's pattern, why isn't the victim's statements admissible to show her pattern?
Right, so well, it's kind of a complicated question. So I'll just try to start breaking it down. But the rape shield law protects victims being attacked with evidence of their prior sexual conduct because their pattern of sexual conduct isn't probative on what typically is the issue in a sexual assault trial, which is consent. And here, that's really what the issue was consent. The defense theory was that she consented to this. This was a sex for fee case, and that she didn't want to pay the two men that drove her there, so she lied and claimed she was raped. Her pattern of sexual conduct in the past, including a Fall River incident, whether she was raped or not, whether she reported that she was raped or not, it's still a past incident of sexual conduct, and it's really not probative on what happened in this case. She's a different person from, the defendant's a different person than the Fall River guy, and, there's case law that says just because a prostitute or a victim has consented to sex one time, sexual intercourse on one occasion, doesn't mean that they've consented to it on another occasion. But also, her pattern, it's a collateral. It's not an element of the offense on trial. It's not. It wasn't at issue in this trial, like for the same reasons that whether she consented in that case or not, isn't relevant to whether she consented in this case. So it's not even an issue, a main issue in this case. So it's a collateral matter, and the judge has significant discretion in determining how someone may or may not be cross-examined as to a collateral matter. And I think it's an appeals court case that my sister cited in this case, in her brief, that says a defendant's pattern, for example, prior bad acts of a defendant, can come in to rebut the theory of fabrication to support a witness on the stand who's claiming that it was not consented to during the incident at issue. But there isn't a case that says, that I know of off the top of my head, that says you can use pattern or habit in the same way against a victim. There's a rape shield statute that says you can't. And then there's exceptions to it, the Bohannon fabrication exception or a bias. And here, I do want to touch on bias really quickly. There was enough evidence pertaining to the incident at issue that showed, or the judge or the defense could have made a case for that strictly pertaining to the incident issue, all he had to argue to the jury was that she lied in this case because she didn't want to pay them. He didn't have to use a possibly or an allegedly prior false allegation of rape to show bias in this case. The Commonwealth still struggles to see how that would show bias in this incident. The stronger argument to the jury, the Commonwealth thinks, would be focusing on this incident and just saying, here's a reason for her to claim rape here. And so I think the defense on appeal needs to argue to you that the judge was wrong when the judge allowed the defendant, if he laid the proper foundation, to introduce the Fall River incident, assuming there was a proper foundation that showed it was possibly a false report of rape. But and the defense on appeal needs to show that the judge was wrong, that it shouldn't have come in for that reason, that it should have come in as a prior inconsistent statement, because that's really the only way that the defendant can make any sort of argument to you that maybe the judge wouldn't have allowed the Commonwealth to rebut that evidence in the same way. Does that make sense? I know it was really wordy, but I think I'll just rest on the brief if you don't have any further questions.
No.
Okay,
Well,
thank you.
thank you both again. Another interesting case, well argued. Case is submitted.
Thank you, Your Honors.
So we're going to hear, in a moment, we'll hear the third case of this morning, and then just for those who are waiting for cases 4, 5, and 6, we'll be taking a brief recess after that case. So calling the third case now, Commonwealth versus Williams, 22P373.
Good morning, and may it please the court. Nick Madison for Farmion Williams. This case involves two related issues of the application of the exclusionary rule and the right to present witnesses to a fact finder in probation violation hearings. Also, issues of sufficiency of the evidence. Turning first to the exclusionary rule issue, the Supreme Judicial Court in Olson left open the question of the extent to which the exclusionary rule should apply where officers know or should know of the probationer's status of being on probation.
Where in the record is there evidence that Officer Leone knew that the defendant was on probation?
Your Honor, there's substantial circumstantial evidence that Officer Leone and the rest of the unit knew that he was on probation. He was on, throughout all of the period of that covered by the testimony in this case, he was on the same period of probation. He had previously been arrested approximately 10 months before by this unit, the DCU of B3, the drug control unit. Officer Leon had testified at a previous hearing, and then most saliently, well, two salient issues. The first is some 3 months before the arrest that gave rise to the probation violation, Mr. Williams had filed an internal affairs complaint against Officer Leon.
We have that in the record?
It was testified to at the hearing.
But we don't know what the grounds for it was.
The grounds for the internal...
From the record. We don't know what the grounds was for the internal affairs complaint.
I believe there's testimony that Officer Leone understood the grounds for the complaint as being related to his testimony at the hearing, at a hearing on this earlier unrelated arrest. And so you have the internal affairs complaint. There was testimony that everybody in the unit knew of this internal affairs complaint.
But how does that get Officer Leone to know that the defendant is on probation? I understand he testified the defendant had done a 10-year state prison sentence, but that he's currently on probation, because that's what Judge Abrams was focused on in Olson when she talked about whether police are venal enough to target probationers.
Offering the internal affairs, just that Mr. Williams, who was on the same term of probation, was well known to this unit, who had arrested him while he was on the same term of probation, and presumably would have run his record at that time. But even more saliently, to Your Honor's point, both officers within the unit testified to a practice where before they conducted surveillance operations, they would look through whatever databases they have on the target of the investigation, and that they did that both officers said that they did that in this case. It's
Is there evidence that whatever databases they have showed whether or not the defendant is on probation?
No, that is not in the record, Your Honor. But I would point out that there's extremely strong circumstantial evidence that they did know of this, and if Judge Halal, when deciding the exclusionary rule issue, had the easiest way to resolve that issue would have been to make a finding that they did not know that he was on probation. He did not do that.
Or for the defense attorney to ask the question, Officer Leone, you knew that my client was on probation, didn't you?
Certainly, defense counsel could have asked that way, but state of mind, as is often noted, is capable of circumstantial evidence. I think there's extremely compelling circumstantial evidence here that the officers and the unit did know that he was on probation from all of their familiarity of him and from their research on him immediately before the surveillance operation in this case.
Is it your, I'm sorry, is it your position that police are forbidden from investigating folks who are on probation, whom they know to be on probation?
No, of course
not. Is that
not.
what Olson stands for? No, okay.
I'm sorry, I missed.
That's not what Olson stands for. You're not suggesting that Olson stands for the proposition that police are forbidden from conducting investigations on people whom they know to be on probation?
No, Your Honor.
Okay.
The only
So
question.
what else then need there be in order to trigger this application of the exclusionary rule into the probation violation hearing?
So
What more do you need?
I would just clarify that the issue with Olson is what is the threshold to trigger the availability of the exclusionary rule, not any limitation on what police can do, just if the evidence will be admissible thereafter.
And what's your position as to what that would be?
Yes, Your Honor.
Because again, it's rather vague, and I think, as Justice Grant has pointed out, as to whether they actually knew for a fact he was on probation. They certainly knew he had a criminal history, pending cases, other cases in which they themselves were involved. But that's very different from knowing that he wasn't incarcerated, wasn't sentenced, wasn't found not guilty, or had the case dismissed, and all sorts of possibilities there.
Certainly, Your Honor. There was testimony at the hearing that for one of the people during the investigation, they, quote unquote, ran him on their department-issued phones at the time. And so just these officers are very capable of getting Corey information on people that would have revealed. And the record shows in this case is Corey, in fact, did.
So again, suppose for a moment they ran him and they see, oh, he's on probation. Are they supposed to then stop their investigation and say, avert our eyes?
No, Your Honor. What Olson is concerned about is the possibility, the need to deter either intentional or indifference to the violation of the rights of people on probation. And so what you'd be seeking to deter in this case during the investigation is for police to be as solicitous as they would be for any other criminal defendant to their constitutional rights, knowing that if they violate those rights, any evidence uncovered could be found inadmissible and unusable in a prosecution, or in this case, a probation violation proceeding.
So that leads me to another question, and I guess, how do we know what we're doing here, and why don't we just remand this down to Judge Halal to give us an idea of what exactly he thought of the motion to suppress that everybody agreed was going to occur, whether that was a good approach or not? But
So, Your Honor, I agree, and the Commonwealth has argued that Judge Halal decided the motion to suppress. The record does not support that. He made no findings. There were two separate motions, a motion to apply the exclusionary rule and a motion to suppress. The only one that was acted upon was the motion.
And he doesn't make factual findings either. He says, I credit the police officers, right? But he doesn't make actual factual findings with respect to, because I see your brief colors the facts a little bit differently and understandably than the Commonwealth's.
So, yes, there were no factual findings made. So even if Judge Halal had decided the motion to suppress, a remand would be necessary for the factual findings in order to allow appellate review of that ruling.
We can't look at it and say, oh, they're uncontroverted, or everybody everybody's on the same page of the facts and we can just apply the law in this case. That's your...
No, Your Honor. And there's case law to the point that just because that there is evidence in the record, even uncontroverted evidence, doesn't require a judge to credit that evidence. A judge can selectively credit evidence even when it's uncontroverted. If I could turn to the issue of presenting witnesses, beginning with Gagnon and Morrissey and continuing through Durling and Hartfield more recently, appellate courts have articulated that the minimum requirements of due process require to be heard in person and present witnesses in front of a neutral and detached fact finder. That didn't occur in this case when Judge Halal declined to allow Mr. Williams to call live witnesses in this case who, as I averted to before with Judge Grant's question, a specific credibility challenge had been raised, and the judge would need to resolve that credibility challenge in order to find Mr. Williams in violation. And so...
Oh, go ahead. Sorry.
And so when Judge Halal refused to hear that live testimony, refused to observe these officers after Mr. Williams had invoked his right, his due process right to present witnesses, that denied him his right.
Well, he actually had presented these witnesses to another judge, right?
He had, Your Honor, but that judge had declined to, that judge was sitting as the fact finder at the time, declined to continue with the case, and so there was a new fact finder.
Well, it's because he actually did continue the case, and he scheduled a hearing to which your client didn't show up, right?
That's
and that's
correct, Your Honor.
So the only reason that we didn't have, there was any issue of your client not presenting witnesses is that he left. He sort of, as the judge said, didn't he kind of waive that right by not showing up?
You're correct, Your Honor. The reason why there was the necessity of two fact finders was due to Mr. Williams' default, but as I've noted in my brief, the judge did decide this on the issue of waiver. He found pretty clearly that Mr. Williams had waived his right.
What information did Judge Halal have about what happened at the hearing before Judge Krupp?
So he had the transcript and of the hearing, and he had the he asserted that he listened to the FTR recording.
He asserted.
Well, he said that he did. He put on the record that he.
Are you asking us to infer that he
No,
didn't
I wasn't
actually?
meaning to imply that he didn't at all, just that
your
happened.
Your brief says in a few places that he had the transcript, but you kind of omit the fact that he also listened to the FTR.
I wasn't meaning to admit that fact. I think listening to the transcript, listening to the recording certainly helps, but I cite a number of cases in my brief that visibly observing in your presence a person testifying, whether you're a judge or a jury, whoever the finder of fact is.
Do you know if the witnesses before Judge Krupp were masked?
I believe there was an objection on the record that they, I'm not positive to that answer, Your Honor. I believe it might have been discussed at the hearing because this happened in the height of COVID.
Are you sure defense counsel didn't say he had no objection to the masks?
I won't represent either way this because I'm unsure about that. I believe it was talked about at the hearing.
Let me ask you, what do you say to the proposition that, and I suspect the case you're looking at as far as the watching the witnesses to assess credibility are older cases, and to the proposition that actually listening might eliminate implicit biases that a fact finder might have without actually seeing the faces, if you will, of the folks that they're listening to, be it police officers or other witnesses?
Certainly, implicit bias is something to be concerned about, whether you're a judge or whether you're a juror in a fact finder case. But I guess the closest recent parallel would be the Zoom cases, what can proceed via Zoom and what cannot. And in those cases, the courts have been very clear that it needs to be as close of an analog as possible to, when it's allowable, to get as much of that information as you would get, as is humanly possible, to being in the courtroom observing the witness testify. And the judges, as far as I'm aware, no court has said that merely hearing the testimony is the same thing as observing somebody, observing their mannerisms, observing if they look comfortable, are they glaring at the defendant. There's all of these visual cues that appear when somebody is testifying that a fact finder can use to make credibility determinations, which was essential to resolving the issues in this probation.
Reading the transcript of when your defense counsel wants to put on Officer Leon again, and says, because I want to ask him about this IA report that I really didn't get to ask him about before. He doesn't ever say, you can't, that I want him to testify again about what happened, about the facts here. He kind of wants to just put it on for a cross-examination. So he doesn't say you can't rely on the other testimony. He doesn't make that objection. He just says, I want another chance to cross-examine him.
What I understand, and there were two preliminary hearings in this case where there was back and forth. I believe one was on November 4th and one was on November 15th, where there were discussions about what the scope of the hearing.
Yeah, it was the 15th one I was referring to.
The Judge Halal. There's also some conversation about that in the 4th. My understanding of the nature of the proffer was, Judge, there's a specific credibility arising from the prior filing of this internal affairs complaint. I would like you to observe him testifying. I think you, as the fact finder making credibility determinations, need to observe him testifying on these issues in order to make that credibility determination. That's my understanding of counsel's proffer at the time. And just to...
And there was cross-examination about that before Judge Krupp too, right?
That's correct. But Judge Halal did not get to observe him testifying either in general or about the existence of this internal affairs complaint that was evidence of bias.
Well, I also wanted to ask you, Judge Halal found that your client was in violation for failure to report to probation between 3/16/21 and 9/20/21.
That's correct.
Can't we affirm the revocation of probation on that basis alone?
No, Your Honor, because this is a Supreme Judicial Court's case of Arroyo, where if a violation was found on multiple bases, and one of those bases is found to be infirm, a remand is necessary for the judge to make the discretionary decision of whether or not he's going to revoke on the viable bases. So if you take one of them away, it may have affected the judge's discretionary decision of when to revoke. That's cited in my brief. I also believe...
It doesn't affect the finding of violation, just as to whether to revoke and what sentence to impose, you're saying?
That's correct. It would not affect the finding of probation, but a remand would be required as to whether or not to revoke and the disposition thereon. I see my time has expired. If there's no further questions.
Actually, I do want to ask you one question beyond the clock here. You brought to our attention the fact that the SJC has taken a case just like this. What should we do what do you think we should do in light of the SJC having taken the case?
Certainly from the amicus solicitation, it appears like it's going to touch on similar, the context seems a little bit different, but touch on similar legal principles.
So my question is, should we stay this appeal and wait for the SJC?
To the extent that this court finds dealing with the exclusionary rule issue necessary in the context of deciding this case, then it might be prudent for the court to await resolution of the Jellins case, apply whatever guidance the SJC may have, and then issue the decision in this case.
Okay. Thank you.
Thank you.
Good morning, and may it please the court, Mackenzie Slyman on behalf of the Commonwealth. If I may, I'll start where the court left off with counsel as to Judge Halal's decision to not permit the defendant to essentially restart this hearing, call witnesses that had been fully cross-examined, fully directed by all the parties when the defendant was present 10 months prior at the beginning of this proceeding. That was certainly within Judge Halal's discretion to do so. And to answer, I think, to set the scene here, your question, Justice Grant, as to whether masks were worn, I looked briefly at the transcript from February 5th, and there is a back and forth between Officer Leon and defense counsel where he could not hear the officer's response clearly, and the defense attorney said, sorry, the mask just adds a little piece to this to you, so no, it's not on you. The inference there being the defense attorney had struggled a little bit to hear in the courtroom at that time because the officer was masked. So I think that that is especially relevant here because Judge Halal was in a perfectly situated, was in a plenty fine position to assess the credibility of everyone who had previously testified on this case. Not only did he review the transcripts from the case, but as I think he repeatedly referenced on the record, he did listen to the audio recording of the hearing. He was able to hear there. And prior to doing that, defense counsel had honed him in on this is where our credibility concern is with Officer Leon, with his understanding, his prior interactions with the defendant, his knowledge of the internal affairs complaint, all of which had been fully explored at the first day of the revocation proceeding.
Does it matter what the internal affairs complaint is about? I understand it's not on the record, but does it make a difference if it's terrible racist behavior, beating defendants versus spelling someone's name wrong on a police report?
I think the most it would be relevant would just be to an overall credibility determination about that officer, given the defendant who's obviously has, a self-serving interest in filing the complaint, given how he reports that the incident took place. I think that would be the extent of it because even if, and I don't suggest the record supports that here, even if the court were to, even if there was, in a hypothetical sense, evidence that any of these DCU officers had a bone to pick with this defendant, the court should still be looking at what was the actual investigation done here, what was the actual conduct done on this day. So again, I think that would potentially inform an overall credibility determination about the officer, but I don't think that it would dictate the actions on that day. I think that would be viewed objectively. So again, Judge Halal listened to the FTR. He was able to hear the tone of the conversation back and forth between the attorneys and the witnesses. He was able to read it, but he was able to hear from that. Did it ever get combative between the two? Did the witnesses ever hesitate in their answer? Did they, there's plenty that he was able to judge from listening to the recording. And again, we're not in a situation where this is hearsay we're dealing with. This is testimony that was given in court where the defendant, again, was present, had the opportunity to be heard in person on this, and where all the witnesses were cross-examined by the Commonwealth's attorney and defense counsel. So for all
can I ask
those...
you a question? I'm sorry to interrupt. Do you know if the defendant filed a motion to suppress, whether it was heard in the Dorchester District Court case, or the BMC case, I should say, and what the result of that was?
So the defendant has been indicted on these new
okay.
offenses. The case is now in Superior Court. My most recent check of mass courts is that there has not been a suppression hearing yet. Right. I think one had been scheduled but had been moved along, and I'm frankly not even sure that memos have been filed yet. But we don't have any decision from. So
can you help me then with this conundrum, if you will? So in order to get to should the exclusionary rule apply, right? We need to know if something should be excluded.
Of course, of course.
And the brief seems to suggest that Judge Halal may have touched upon those issues, but can you tell me where and how? I looked at the docket, it's not on there. I looked at the motion itself, it's not endorsed. He doesn't make factual findings, not to be critical of not doing that, and it may be part of it was Judge Krupp passing the ball off and something got lost in translation, I don't know, but where are the findings, factual findings, or any legal rulings as to whether suppression was in order?
Sure. So I will acknowledge there weren't formal factual findings made. I think my best argument to you, Your Honor, is that if you look at the judge's margin endorsement and what he said orally, that it suggests that not only was he ruling that he was not going to apply the exclusionary rule here, but that he was going to deny the motion to suppress. The margin endorsement, the court declines to apply the exclusionary rule to this probation revocation here. Moreover, there's nothing in the record to suggest the officers engaged in any harassment of the defendant. But looking at what he said orally in court.
That seems to me that would go to the sort of the Olson point. Like they're not focusing on this person simply because he's on probation. And it seems to me what Olson is saying is, don't go fishing for guys on probation because that's an easy way to pop them off the street, right?
Sure,
I mean, That's kind of what Olson's.
And perhaps I have a little bit more support in what he said orally. He said, I'm going to I'm going to deny the motion. I'm not going to apply exclusionary rules. So he does go then into more of an explanation of the exclusionary rule. But then he says, so for those reasons, I'm going to deny the motion and decline to apply the exclusionary rule. I think there is a reading there that he was denying the motion to apply the exclusionary rule and the motion to suppress, even if the court does not find that that was explicit enough. I think the court can assess the testimony that was entered here, even without explicit factual findings, because it is implicit in Judge Halal's ruling that there wasn't harassment here, and that in his ultimate findings that there was.
But if you will, I mean, again, the briefs characterize the evidence differently. You say, on the one hand, you know, a couple of quick pop in the car, get out of the car, that's your classic quick buy. Defendant says, well, it's several minutes. That's really not your classic buy. Your classic buy is in the car, out of the car, matter of maybe a minute at best, and then they walk off the scene, it's whatever it may be. This is somewhere, it seems to me, less than clear in terms of your classic just hand to hand and go, and then, right? And then in terms of where the gun was located, I think there's some, at least if not explicit in the defendant's brief, some suggestion that the tie to the gun is not quite as clear as the Commonwealth makes out. I mean,
I'm sorry, the what of the
tie to
gun?
the gun, the fact that he could have seen the gun when he leaned in the car or whatever it may be.
I would disagree to that last point, Your Honor, because
Sure,
I would first.
concede that one, actually. Go ahead.
I would first direct the court to, I believe it's page 27 of the appendix, which is a photograph of where the firearm was located within the vehicle. It's very clear that it's, as was testified to, right between the passenger seat and the center console. Going back to the live testimony that was taken, the officers observed the defendant lean into the front driver's seat, I believe it was driver's seat, but into the front seat, be in there for 3 to 5 minutes, a significant amount of time to lean into a vehicle where he's, leaning over the center console, leaning in that area.
Yeah,
where this gun
put
is.
that one aside. Okay, let's leave that one.
Sure.
Talking about getting probable cause, talking about how we get to a set of facts from which we can then analyze whether there was probable cause to arrest Mr. Williams.
Sure, and I'll answer kind of in two ways, Your Honor. First, I don't think the court even has to get there. I think that Judge Halal's rulings on the exclusionary rule part of this and how thorough he was with that there was no harassment, there was no evidence that this was solely because of knowledge, which I agree with earlier that it's not clear at all from the record that they were aware that he was on probation. I think it's a reasonable inference that they didn't. Putting that aside, if the court does want to look at the actual merits of the suppression hearing, which again, I don't think whether it is that there was probable cause, whether there isn't, we still have sufficient rulings from Judge Halal as to the exclusionary rule. But I think if we track back from his ultimate findings of a violation here, that tracks the factual findings here. And again, I acknowledge that there weren't specific ones made, but where the judge found that the defendant had committed the new offenses related to the firearm, inferentially to get there, he connects that there was probable cause to get into the vehicle in the first place in order to assess and to recover the firearm. And that, again, spawns from, as I write in my brief, all the observations of the defendant, the people coming back and forth from the vehicle, their knowledge of this being a high crime area, seeing him exit the vehicle to begin with something in his hand, and then ultimately maintaining a visual of Mr. Teague, the second person to enter and exit the defendant's van, and see him drop something from his hand that he exited the van with. So I think leading backwards, it illustrates that the judge credited the testimony that was presented in front of him of the nature of the investigation, of the observations that were made, that ultimately lead to entering the sedan in order to get to the firearm, where he found that was sufficient for a violation. And again, I'll circle back to the fact that even if it's either left an open question, or if this court does review and find that there wasn't probable cause to believe that there had been drug transactions, that only gets us, as you alluded to earlier, Justice Brennan, to the question of, all right, now, are we in a situation where the exclusionary rule should apply? And that's where we get back to Olson, back to Simon, about is there evidence of police harassment? Is there evidence of...
What do you say then to Justice Massing's question about what do we do about the case that's currently pending at the SJC? Do we wait and see what they say? Do we try and forge ahead on our own and figure out where we think they're going?
I admit I'm not fully familiar with the full context of what's currently pending for the SJC, so with that in mind...
The briefs are available. I tried to look. I don't know if you could find them, or if you may have them.
Sure. I mean, the court could stay this in order to see how the SJC rules on this. Again, I apologize that I don't know the factual standing of that, but I think it's important here that Olson left open the question of if we're dealing with a situation where officers are aware of the defendant's probationary status, is the exclusionary rule fair game potentially? The appeals court case, Simon, delves into that further about, all right, now that we have a situation where the officers are aware that the defendant's on probation, now what should we be looking at, what should we be considering? And that's where they look at, was that the sole focus of the investigation, the fact that they knew he was on probation, and was there any evidence of harassment in that case? And I would point the court to a federal case, Gravina, that the Commonwealth does cite in its brief. It's cited in Simon when the court is contemplating their harassment and, police misconduct that would get us to that point. And the portion.
Can I hold you for a sec? I don't know if have you seen the docket on, have you looked at the docket on?
Jelen.
Yes, on Jelen or Gellen?
No, Your Honor.
Okay, so that says, I'm just reading from, it's kind of small, but whether this court should reconsider or modify the rule set forth in Olson regarding the applicability of the exclusionary rule to probation revocation proceedings on the basis of, among other things, change circumstance regarding the ability of law enforcement to access data regarding the probation status of individuals in real time, and the alleged disparate impact of the Olson rule on racial minorities, and whether the rule's applicability to motions to suppress are based on alleged equal protection violations. I'm not sure how many of those touch here, if any, but at least one, maybe two. It's not terribly informative, but any thoughts if that contextualizes it at all for you?
Sure. Again, I apologize for not being familiar with the docket on that. It's not entirely clear to me from that if there's a true question of knowledge of probationary status, if that would change things. I think that, of course, this court could stay this case and just wait to get a little more guidance from the SJC on that question. But I think Simon puts the court in a perfectly good position to assess whether this judge erred in not applying the exclusionary rule. My search of the case law, there's never been a situation where an appeals court has held in Massachusetts that the denial of to invoke the exclusionary rule was in error, nor has there been a case brought up since Simon, not that Simon did this, but where a judge did apply the exclusionary rule in an appeals court or SJC weighed in on that. So I think working within the contours of Simon, where again, it lands us in this position of, was there harassment here, and was the interaction with the defendant purely motivated by knowledge of probationary status. I would say Judge Halal's decision here, where it may not be entirely, I might be in thin air as to his conclusions about the merits of the motion to suppress. I think it is incredibly clear that he ruled that there is nothing in the record to suggest that the officers engaged in any harassment or stopped him because they knew he was on probation. And I would point the court, as I was saying, to a federal court case, Gravina, that is cited in the Commonwealth's brief. It's cited, again, in Simon when they're contemplating harassment. There it says that harassment needs to be more than a repeated, it has to be an element of constancy that should be present in order to invoke the exclusionary rule. If it's a singular act, at least some irregularity in the conduct of the police officials must be present. There's no suggestion here of irregularity. And I would point the court and to further in that opinion, we're in a very similar situation than we are here, where the defendant was arguing that the investigation by police itself constituted harassment. And in Gravina, they say that argument must fail because it would essentially render persons on probation and supervised release immune from all investigation during that release period. That there is no evidence of a campaign or a conspiracy to induce the defendant to violate the terms of his release, that the defendant needed no such prodding. I think we find ourselves squarely in that same factual scenario that the
I have a question for you about Jelen. The SJC's docket in Jelen notes that the blue brief has been filed and it's impounded. The red brief has not been filed. Then the SJC solicited amicus briefs. Did you do anything in preparing for argument today to find out whether there's a mechanism when the SJC solicits amicus briefs in a case where the briefs are impounded, whether the SJC has a way of enabling the people who might want to file amicus briefs to find out more about what the case is about? Did you do anything about that in preparation for today?
I did not, Your Honor. It is a very good question of even where there is a solicitation for amici, is where the briefs are impounded, what information will those outside parties have to work off of? And I think that, that may be a hindrance to that applicability. Perhaps there is an avenue for the SJC to unimpound or, release those via protective order, but I'm not personally aware of a mechanism there, which I think to a degree means that this court.
This case, too, is partially impounded. Why
It
that?
is I believe it's just the defendant's board of probation record that was submitted as an impounded appendix. I think that's the extent of the impoundment here.
Might be the case in the SJC, too.
It's a crime against the person,
Okay,
so I don't know.
yeah. Okay. Well,
If you guys have further questions.
again, you've kept our streak of starting off the court year with excellent arguments. Thank you both. The case is submitted. We'll be taking a brief recess, as is our custom. We'll be back in no more than 15 minutes to hear the DCF case.
All right, please.
Sorry.
Thank you. We're back on the record calling the fourth case today, which is 22P1048, Department of Children and Families versus Mother. I don't need to remind you, but I will anyway, that this is an impounded case, so we don't refer to anybody by names. But there's a lot of children involved here, so maybe we could just say the twins, the 4 older ones, and leave it at that.
Thank you. Good morning, members of the panel. May it please the court. My name is Natalie Hoppel, and I represent the appellant mother in this matter. Your Honors, in light of this court's decision last week in the companion case involving the twins' elder siblings, I believe the Indian Child Welfare Act issues set forth in Mother's brief remain of interest to this court, and I would like to focus my time today highlighting the lack of ICWA findings made by the lower court, the scarcity of ICWA information contained in the record, and the overall lack of the lower court oversight regarding the department's ICWA inquiry, due diligence, and compliance with ICWA. In its responsive brief, the department perplexingly states, without citation to the record, that the children were found not to be Indian children, and then goes on to indicate there was nothing improper about the lower court's determination that ICWA did not apply to the subject children. However,
That determination was made very early in the case, right? Where there was a colloquy where your client was asked and she said no.
yes, Your Honor, that colloquy did happen in 2018, but successively in 2019, the department took steps to send out ICWA notices to the tribes.
Right.
At that point in time, the reason to know standard that's set forth in ICWA would have been triggered. That's 25 CFR 23107. The reason to know standard means that the department found something somewhere, which we don't know about, which indicated that there was reason to know that these children may be Indian children, hence the notices were sent out in 2019.
I want to thank you for the 16L letter and bringing the other case to our attention, which was very helpful. And just explain it to me. If there's any tribal relationship for these kids, doesn't it derive from the mother?
Your Honor, it derives from the mother or potentially the father. The other piece of information that's also relevant to this case is that in 2018, the father of the twins had not been established. The record indicates that the father of the twins was not established until 2020. Concurrently with the lineage for both parents, there's also the issue that the notices that the department referenced, they did not reference any notices that were sent to the Bureau of Indian Affairs. And there's a regulation on point, Your Honors, and it's 25 CFR and it's 23111 that indicate, there's a regulation on point, Your Honors, that does indicate that where one of the parents is not determined or unknown, that the Bureau of Indian Affairs needs to be notified as well as the tribes. So the record does let us know.
Can I ask you, is that on every single circumstance where there's an unknown father, the tribes are notified?
Yes, Your Honor. I would argue and I would assert that under the regulation on point, which I'm looking for, Your Honor, the identity or location of the child's parents, and that citation is 25 CFR 23111, and it's para E. It says if
Sorry, say that again slowly.
Yes, 25 CFR 23111, section E.
Okay.
And in that particular regulation, which is applicable across the board, anytime, again, there is a reason to know there may be Indian children involved, if the identity or location of the child's parents cannot be ascertained, but there is reason to know that the child is an Indian child, notice must be sent to the appropriate Bureau of Indian Affairs regional director.
Does the reason to know have to be specific to that parent? So in other words, if we don't know who the father is, why or how could they have reason to know that the father had some connection to a tribe?
I think in this instance, Your Honor, where there are fathers, there were putative fathers involved in this case. There were also paternal family members that were involved in this case and were also placement individuals. In that situation, the department has the ability to go and ask those family members, and that is something that's contemplated in the regulations, the 2016 regulations, where there's an inquiry portion here. There's notice, which Justice Gorsuch indicated is the touchstone of ICWA, but underpinning the notice requirement is the inquiry, and that's a meaningful inquiry. So it's to ask, not to simply say, no one's related here to a Native American grandparent or grandfather or relative, right? As opposed to, can you tell me about your Native American heritage? What can you tell me? What's known within your family? What traditions are in your family? That meaningful inquiry is absent from this record. There's nothing in the record to tell us that the lower court went into the department and said, yes, okay, you sent the ICWA notices, tell us what you did. Where's your due diligence?
Would you be making this, so this was not, none of this was argued at any point during the trial? And if you look, there are a few little points in the record, and there's a few places where it says ICWA, right, on it. If those weren't on the record, would you still have this argument?
I think, Your Honor, if those were absence from DCF record, it would be more difficult to make this argument. It's the idea, though, that we have a federal statutory scheme and regulations that mandate that every trial court in this state is required to go through the ICWA colloquy, inquiry, and to make sure that there are no Native American children who are participating in these proceedings. That's the federal mandate that was set forth when Congress enacted the Indian Child Welfare Act. So it applies across the board. In this particular case, where there are these conflicting pieces of information that exist, that is something that is properly brought up at the trial court. It wasn't. But here on appeal, because of the collateral attack statute, which is 25 U.S.C., I believe it's 1914, that allows for post-adjudication punctures of any lower court judgments.
That raises, so why should we not, I mean, it's not on the record, why should we not just say it's waived here, and you can go back to court, we affirm, and you go back to the probate court under 28 U.S.C. 1914 and collaterally attack?
I think the request that Mother's looking for in this case, or the relief that Mother's looking for, is the determination that the trial court did not carry out its mandate under ICWA, under the regulatory scheme, under the statute. It was not done in the trial court.
But why can't you make that by a collateral attack?
I think the idea would be...
Because how can we can't say that, we don't have any record of it.
And Your Honor, the idea would be to remand for an evidentiary hearing in the lower court and order the lower court to carry out an evidentiary hearing and look into the ICWA issue and require the department to report to the court as is required in the regulations.
So, excuse me, can I,
Yes.
assuming for the moment we do that, on that very narrow issue,
Yes.
and the lower court determines that there is a tribal connection, what then?
Your Honor, at that point in time, my understanding is it's a reset to some extent, to a limited reset, at which point the lower court would take in information from the parties and other involved from other involved parties, and then they would determine which tribes should be notified.
But again, a tribal connection doesn't impact her fitness to parent these children, does it?
Your Honor, the entire application of the statute changes the burden of proof. It changes the entire stance of the case. So rather than the clear and convincing standard, we're looking at a beyond a reasonable doubt standard. In addition to that, beyond reasonable efforts, we're looking at active efforts. So it's the entire stance of the case and what happened while this case was pending. When you look back to the stipulation in in 2019, up at that point when the department knew and was sending out ICWA notices, theoretically, the ICWA should have been applicable at that point in time, and the department should have been held to those higher burdens, the active efforts requirement, and the idea that until there was an adequate response from all of the applicable tribes that these children were not Native American, at that point in time, then the court could go down to the lower burden of proof that applies to regular child welfare proceedings.
Is your client still incarcerated?
I'm sorry, yes, Your Honor.
And has a manslaughter case gone to trial, or is it resolved?
Your Honor, that case was settled. My client did settle that case. She is.
They settled, she pled guilty?
She did, Your Honor.
Okay.
Yes.
To manslaughter or to the reckless endangerment?
I believe it is both, Your Honor.
Any sense of what the sentence was?
I believe it is 3 years, but there was, at the last time I checked, there was time for credit served that was being calculated that had not been conducted by that particular court, the Superior Court, yet. So that was in flux, and there were some terms of probation as well.
Got it. Thank you.
Your Honors, may I continue with my prepared? Thank you. Your Honors, another perplexing ICWA omission. that I'd like to touch upon, or I guess one thing that I would like to address in terms of adoption of Irma, which was the case was decided last week. I'd like to address mother's denial of her Native American heritage in the record, and both fathers' denials as well, and that's found at EA2, page 37. I'd like to let the court know from at least mother's stance, these denials are simply another piece of evidence that was not addressed by the lower court in its findings. Giving too much credit to a parent's denial of their Native American heritage undermines the tribe's sovereign ability to, and sole authority, if you will, to determine who is a tribal member and does not align with the purpose of ICWA. ICWA's statutory framework, regulations, guidelines are intended to address the common sense understanding that over time, Indian families, particularly those living in major urban areas such as Boston or Brockton, may well have lost the ability to convey accurate information regarding their tribal status. Reliance on mother or father's denial of their Native American heritage to uphold a lower court's decision ignores the reality that parents may not know the details of their possible relationships with or connections to Indian tribes.
So the injured party here is some unknown tribe or the BIA?
The injured party would be both the Indian tribe, or both the Indian tribe, would be any of the unidentified Indian tribes, along with the children who have now been denied their potential Native American heritage. And the other thing I think that would be helpful for the court to understand. Yes.
Seriously, is there any, what basis do you have to say that they have in Native American heritage?
Your Honor, I'd like to be very careful to stay within the record, but in terms of tasks that I would argue that the department should have engaged in terms of Native American heritage, one would be to search the Dawes rolls, and that would be after potentially interviewing.
Have you searched the Dawes rolls?
Yes, Your Honor, I have.
Any luck?
Yes, Your Honor, luck. Yes, I've actually.
Pardon my ignorance,
Yes.
which clearly Justice Massing doesn't share, but
No, I do too, I was just pretending.
can you tell us what that is?
Yes.
Thank
So
you.
the Dawes rules were created by the federal government, and it was as a result of, I believe,
Is that an acronym, or is that an actual?
Actually, the Dawes Rolls, it's the National Archives and then also the Oklahoma Historical Society. They actually have a separate database that you can search the Dawes Rolls for. So what had happened is, at one point in time in history, and forgive me for not necessarily, I'm going to paraphrase a little bit of the broad history that's encompassing ICWA. At one time, there was a trail of tears from the south up to the north, along with a registration of all the tribes in our country. At that point in time, all the tribes were required to go and register through the Dawes Rolls. So that is kind of almost the snapshot in time for when people were considered members of Native American tribes, and they qualify for membership, and that's one way of qualifying for membership. I want to be very careful in terms of acknowledging the information I did present to you in my reply brief about the Cherokee Nation and the changes to their membership database that had occurred. So looking at the Dawes rules, that's one source of information. Another source of information would be potentially interviewing maternal and paternal family members across the board to determine which tribes need to be notified. The BIA does publish a regulation that does set forth all the federally recognized tribes, and they are not simply just listed to, obviously, the Cherokee, which is listed in this case, but it would be looking to see where mothers and fathers' parental lineage came from. If it's Massachusetts, we have tribes here. If it's going to be down south, there's going to be additional tribes as well. There may be tribes that someone belongs to that no longer exist in a particular state where a family's heritage derives from. All of those pieces of information are something that would be encompassed by a due diligence approach to an ICWA inquiry, which I would assert on behalf of Mother did not happen in this particular case.
Can I ask you about the self-incrimination issue?
I'm sorry, yes, Your Honor?
The self-incrimination issue. How do we reconcile? You cite Howard, which cites Hilton about that DCF can't be used as an arm of the prosecution, but then the other side cites Atkinson, which says that a multidisciplinary team isn't an agent of the prosecution. How do we reconcile those?
Your Honor, I had a hard time understanding why it was proper for the department to go about interrogating Mother through a clinical action plan. In those types of situation, I would offer to the court that where DCF has a dual purpose and they are investigatory as well as interventive, those two potential positions cannot always be reconciled. And I would offer to the court that in this particular case, that is a fundamental problem that occurred, and it's really going to be something that's going to impact litigants who do not have financial resources to have attorneys with them 24/7, or potentially even to get a social worker through a fund type of motion into the state prison if a parent is being held, or have someone with that parent at all points in time to make sure that there is no running afoul of self-incrimination type protections.
But I mean, wouldn't her remedy be to, if anything came out, to have it suppressed in the criminal case as opposed to not speak with DCF?
I think it could potentially be something, but again, that would require, again, some type of oversight as to someone being around mother to understand. And this also, the record is replete with information that mother did have a disability, a mental health disability. So we're putting a vulnerable parent who's been incarcerated and held in a position where she's being required by the state to give up information that could potentially then be used to incriminate her in a criminal case. So that was something that I felt.
If our lodestar is the best interests of the children, why isn't it better to do what Judge Massing suggested and say, DCF has these dual purposes in the multidisciplinary team, and they need to have this interventionary purpose, and so if something comes out that was violative of the mom's rights or was involuntary, they can move to suppress that in the criminal case.
I think it would be something that could be suppressed in the criminal case. I think the danger is that there is potentially a way to get around a suppression hearing. I think I was listening to some of the earlier arguments today about motions to suppress, and it seems to be a highly litigated area where if information comes out, there are usually other alternatives, and it's once the bell's been rung, if you will, that then the information that's been let out is something that's going to be, it puts mother in a predicament. Do I say anything? Do I open up my mind and let you know what I was thinking, what happened, how much can I participate in this interventive services towards having visitation with my children, or am I going to basically put myself in a position where instead of 3 years incarceration, it could be 15, 20, or something else, or maybe escalated or aggravated charges are brought against mother because the clinical case becomes a discovery tool that then can be used to enhance the charge in the Superior Court case. So in a perfect world, if I was able to change things, Your Honors, it would be to bifurcate the department's policy to make it, or approach these cases to make it either interventive or investigatory, and maybe keep those very discrete from one another and specialized so that you do not have the overlap that we do see in these cases where parents are charged. And then there is something, to the extent that I did include information from the federal government, and it looks as though to me that the multidisciplinary task force is a mechanism by which it seems that you can increase your conviction rate. And the question from that is that really the intent of DCF? Is it to investigate, convict, or is it to intervene, remediate, and reunify? And I would suggest that those two policies can't always be reconciled. And I'm concerned, especially in this case, from what I've highlighted to the court, that is something that's ongoing and that does need to be addressed.
So did your client make the decision not to talk to DCF at all then, or?
Your Honor, I think that from an intent standpoint, I think that the idea that when a parent is incarcerated and there are efforts to elicit information that could result in long-term incarceration or escalated charges, I don't believe that my client was in a position to say, you know what, I think I'm going to trust DCF and open myself up to them. So I think that there was a lot going on with respect to my client, and the record does talk about her disability, her mental health status. That would also impact her decision-making. So I don't want to necessarily tell the court I have an answer for you on that point, but I do know that it's something that is a question as to, how my client would have perceived the department's actions towards her, considering that she was incarcerated but still wanted her children to be reunited with her.
So she incarcerated, she was held pending trial?
Yes, I'm sorry, Your Honor, held pending trial.
Okay. One quick question. Your time, we've gone way over time. You make an argument in the brief about grandmother visitation. Did the grandmother request visitation?
My understanding is that at the initial portions of the case, the grandmother was participating in the case, and I would like to at least address my standing argument in terms of that, where I brought up the ICWA argument, and the ICWA would change the entire stance of the case and would have preferences in the ICWA statutory framework and regulations towards reunification with a family member who's Native American. My rationale for bringing up that information and argument in my brief was to highlight the standing that comes from the challenge, the ICWA challenge that Mother brought forth.
But just my, really, I have a much simpler question. The statute says that upon request that, they should consider a grandmother visitation, but if there's no request, there's nothing to consider.
I don't believe the record there was a formal request, but my understanding is that there were clinical requests for contact with the children by extended relatives, and Mother also sought, I believe, with a cousin to have the children placed down south with a cousin as well.
And has there been any problem with sibling visitation?
Not to my knowledge. I believe my brother might be able to address sibling visitation, but I do stress to the court the concept of having a clear order that's enforceable amongst and across case law that would really let the children know. And I think, again, Mother, because of her ICWA status and her desire to, still have a relationship with her children, it is of a concern to her. And she did, at the outset of these proceedings, before trial, she did try to make an effort towards having the children all placed together, understanding the bonds amongst all the children are something that should potentially, and we would have been better addressed with an order that applied and was enforceable as to each of the children.
Thank you.
Thank you.
So we'll hear from, I believe that you're dividing your time 10 and 5, DCF 10?
May I begin?
Yes.
Good morning, members of the panel. May it please the court. I'm Kristen Braithwaite, Assistant General Counsel for the Department of Children and Families, and I'm here today asking you to affirm the decrees issued by the lower court. This is a tragic case and one in which Mother doesn't seem to challenge the court's findings regarding her unfitness, and of which there was abundant evidence of her violent and volatile relationships, unchecked aggression, ongoing mental health challenges, and extensive criminal history, culminating in charges of manslaughter and reckless endangerment in the death of her 2-year-old daughter. She does, however, challenge a number of procedural issues, but her challenges must fail as the court's rulings and orders were all properly made within its discretion, and the court acted at all times in conformity with the Indian Child Welfare Act. Mother argues here, just as she unsuccessfully argued on appeal of her companion case, that the lower court was deficient in ensuring ICWA compliance, and as such, the decrees should be vacated. Mother states in her brief that neither the Plymouth County nor Boston juvenile courts or court investigators inquired into this family's Indian heritage, but this is patently untrue. The temporary custody hearing took place on April 30th, 2018 in this matter, and on that same date, the court asked Mother whether she or the children were Indian children. Mother replied that she was not and they were not. Similarly, on June 9, 2017, while speaking with a department social worker, Mother then denied that she or the children have any Indian or tribal affiliation.
What was the date of that one?
That was June 9, 2017. That was prior to the temporary custody hearing in this case. And I would direct you to Exhibit Appendix 1, page 558 for that. Mother's denial of any Indian or tribal affiliation for herself or her children effectively extinguished any reason the court may have had to know that the children were Indian children. And here I would direct the court to adoption of Irma, which addressed the same fact pattern in the companion case. The record here then confirmed the children's non-Indian status in the assessments and adoption plans, which were entered into evidence as exhibits, and which spelled out that the department sent notices pursuant to ICWA on October 23, 2018, and the tribes each sent responses by January 30, 2019, confirming that none of the children nor Mother were enrolled or eligible for protection under ICWA.
And we know that from a reference in a report, right?
It's referenced in an assessment, which was entered as an exhibit. It's also, and I can give you those page numbers. It's also referenced in, so the Exhibit Appendix 2, page 56, is a family assessment that identifies ICWA notices were sent on behalf of Z and Z on 10/23/2018. As of 1/30, tribes report family ineligible for enrollment. ICWA does not apply. These were also included in exhibits that were entered with regards to both of the twins' adoption plans. I would direct you to EA2, Exhibit Appendix 2, page 122, and Exhibit Appendix 2, page 127. This was not objected to by mother, and both indicate that there was no ICWA affiliation.
Is there any reason why, if we were to affirm the decrees here, why the mother couldn't file a motion to collaterally attack that judgment under 25 U.S.C. 1914?
I don't believe there's a reason why she couldn't do so. I don't believe the facts would support that, but no, if you affirm here, she can try to take a collateral step under the.
I mean, the department wouldn't argue, oh no, that's not allowed. It's been waived. It's been.
The department's position is that it really can't be waived, as the tribe has status here. So the department would argue that the mother can't waive tribal rights, and so that wouldn't be the issue, no. I think it's relevant that mother has repeatedly rejected any affiliation. It's only here in this instance. And I would note to the panel, the inconsistencies, I agree, they're there, but they're in 51As, they're in notations, they're sort of typographical, they appear to be errors. Even where there is identification that these children may have ICWA status, their sister, who has the same mother, is identified as not having ICWA status. Whereas if you look to a 51B, which is admissible for primary fact, there's a statement that in fact ICWA doesn't apply. Mother states ICWA doesn't apply. If you look at the exhibits, the assessment, as I indicated, the adoption plans, those are admissible for fact and they indicate that ICWA does not apply. And I would also just add that the determination that comes out of the tribes is conclusive as a matter of law. The tribes have the sole authority to make such a determination, and as stated in 25 CFR section 23.108B, a state court may not substitute its own determination regarding a child's membership in a tribe, a child's eligibility for membership in a tribe, or a parent's membership in a tribe. Neither the court nor the department were with authority to override this finding of ineligibility, which at no time during trial was challenged by mother. And again, while I do believe that that doesn't waive it in that tribes have a right, mother at no point took issue with this. Now, mother argues on appeal that despite her own denial of Indian heritage and the tribe's finding of no affiliation, the court had reason to know that an Indian child is involved. I think it's important here to look at the definition of an Indian child. It's defined under ICWA as any unmarried person who is under the age of 18 and is either A, a member of an Indian tribe, or B, eligible for membership in an Indian tribe and the biological child of a member of an Indian tribe. Where each federally recognized Cherokee tribe confirmed the children were not Indian children under ICWA, and where mother denied tribal membership and father makes no claim of tribal membership, the children do not qualify as Indian children under either prong of this test, and mother's argument fails under statutory scrutiny. And while Massachusetts has not had occasion itself to define reason to know, I would direct the panel to matter of SR, where Montana's Supreme Court addresses this explicitly, holding that a reason to know is not an unlimited standard and requires something more than a bare, vague, or equivocal assertion of possible Indian ancestry without reference to any identified Indian ancestors with a reasonably suspected tribal connection. I would argue that these typographical notations in 51A reports used to form the basis of a quote-unquote reason to know would fall under this test.
Did you cite that Montana case in your brief?
I believe I do. I would have to go back and find it. I can give you the site if it's helpful.
Yeah, what's the site, please?
It's 436P 3D 696, 704, paren, Mont 2019, paren.
In a matter of FR?
SR,
S-
Sam
Sam, okay.
Rasmussen. Mother's suggestion that the court should have questioned the adequacy of the department's representations. Mother suggests that the court should have questioned the adequacy of the department's representations, but this is not called for by ICWA. And Mother's suggestion that we should be following every possible trail or question is actually problematic and runs counter to what the BIA guidelines would suggest. It would flood there's limited resources. We can't go to the BIA and say, maybe someone is Indian, can we run every possible name? That's not what ICWA is intended to do. Mother's speculation that the notices perhaps have a typographical error is devoid of record support. And Mother's accusation of bad faith on the part of the department is, again, completely devoid of record support. Mother suggests that the department is self-serving in finding that there's no ICWA eligibility, but again, I would point to Mother's repeated insistences that there is no ICWA eligibility, which are bolstered by the tribal determination, which is determinative as a matter of law. The court was explicitly authorized under statute to rely upon tribal responses in determining the children were not Indian children and that ICWA did not apply. And Mother provides no evidence to support her claim the court's actions were inadequate. Mother.
Can I ask you to just, we don't have much time left. How do you, isn't the mother kind of in a catch-22 when she's got a criminal case pending and DCF wants to talk to her about what happened with that child?
Well, I will say there's multiple reasons I feel she's not in a catch-22. I would first encourage the panel to look at adoption of Yelena, which makes clear that where child abuse is at play, it is crucial that action plans address the abuse. The children have to be kept safe. The mere fact that Mother faces criminal charges for her behavior does not mean that the department is stopped from trying to work with Mother towards rectifying those parental deficits. That's the first thing I'll say. I know I'm out of time. Can I quickly say one more thing? I would just also like to add, the department was working towards Mother on future progress. Mother's attempt to liken the department's efforts in the action plan to jury instructions look at two different things. The action plan is about future change. Jury instructions is about past action. They are not the same thing. I'm happy to say more, but I recognize I'm out of time.
No, we'll turn it over to Mr. Katz.
Thank you very much.
Yes, you can still say good morning.
I was going to say.
I saw you looking, yeah.
What do you do when it's... Right. Good morning, good afternoon, Your Honors. Daniel Katz for the Twins. I would like to emphasize what my sister here said about Your Honors looking at matter of SR, which is in my brief at page 54. And not only would I like Your Honors to look at the Montana decision, but in my brief at 54 and 55, I've cited some other jurisdictions, and I think those cases also can shed light on this issue of what constitutes a reason to know, even though the standard, we know it's a low standard, but still there has to be a little something. And so in matter of SR, which is 436P3D at 704, the Supreme Court of Montana then said, well, Mother's asserted belief that she may be eligible for enrollment in the tribe was minimally sufficient. So that's kind of the barest minimum if the parent herself or himself says maybe. And here, we not only have one denial when specifically asked by the judge, we also have the evidence in the record that she told the social worker no. And the requirement to have something more than a vague assertion, I think Your Honor should look at the exhibit which does mention, okay, there may be ICWA here, but no source is given. There's nothing else there except ICWA. And I think that bare assertion doesn't meet this low standard that then triggers the obligation on both the court and the department to inquire further. And then if I could also refer your honors to another high court decision from Wisconsin, a different state, obviously, In re Ariana RG, 657 NW 2D 363 at 370 to 372. This was, the Wisconsin High Court says, the father never asserted that the children are members of a federally recognized tribe or that they're eligible for membership, and he's never stated that he has tribal membership. Then, what I find most fascinating, and I hope your honors will also look at, is In re AL, which is on my brief on 55, page 55, from North Dakota. The mother offered no evidence to suggest the children were subject to ICWA. She made no offer of proof at the termination hearing, and she relies solely on counsel's statement about the children's potential eligibility. So what I find interesting here, we also have no evidence proffered by mother below, and we have no request to this panel, or even before this panel was assigned, to enlarge the record to put forth some evidence to counter the two denials that mother said.
Has the, I think Attorney Hopple suggests that, I mean, the last two cases were a couple, like 20 years old, that the regime has changed a bit in 20 years.
Pardon? What is it?
Counsel suggests that there's a little bit higher standard now on state courts since, in more recent years. Is that not?
Well, I think, 2019 from Montana is fairly recent in terms of there has to be more than a bare, vague assertion. And I think if you look specifically at the document or documents that that mother wants this court to look at in terms of ICWA is mentioned, there is no other detail about any eligibility about her or her children.
I want to flip to something else too. These cases are always hard because we're stuck with a static record from a year or two ago, but things have been going on, and we can't help ourselves but ask them. But so, are the twins housed together at this point?
Okay, as I know I'm supposed to do.
Well, no, I'm asking. I'm allowing you to go outside the record.
Thank you, Your Honor. Yes, they are. They are with. So initially, they were with a foster family, and that was going quite well. And they did not want to get in the way of any kinship placement. And so maternal grandmother has the children. They're living together. They are happy, at least from my observations. And I believe the other information is that the Rhode Island, so she now lives in Rhode Island, and I believe that the interstate compact issue has been resolved, and she's ready to adopt.
There's a note. Counsel's passing you a note. I'm just so curious.
Oh, sorry. Thank you. I misspoke. It's paternal grandmother.
I was wondering.
Okay, that's different.
Thank you.
Okay.
Yeah, paternal grandmother, obviously. And they, as you'll know from the record, they haven't seen their mother. They were with their mother briefly for, several months before the incident in question took place. And there was there was no bond. There is no bond. There was no bond, there is no bond. And so any visitation issue should be what should not occur.
Okay. I think we have to call it at that.
Okay.
Sorry. Thank you. Thank you all. Again, really helpful arguments.
Very well argued, thank you.
Case is submitted. Case number 5, we just only have one party here today. It's 22P100 AS versus TS. Mr. Clark, did you get that? Did you get enough time to get that? Okay, excellent. Attorney Helsing, go ahead.
Good afternoon, Your Honors. Stanley Helin, and may it please the Court, Stanley Helin on behalf of the defendant T.S., as it's reflected in the docket.
I have a question about that.
Sure.
It looks from the trial docket as though his last initial is A.
So
What?
I've been footnoting all along throughout pleading, saying it's not T.S., it's T.A. It's never been corrected all the way through, but you
Okay,
are correct.
So, okay.
It's T.A.
Okay.
I don't know how T.S. got into the system, but once it goes in, it's hard to get out. In any event, it's a sufficiency case. I mean, there's not really a lot to talk about other than, there's.
Well, actually, there's one thing to talk about is the case moot. On May 3rd, 2022, it was vacated.
Vacated,
And the
right.
police departments were ordered to destroy all evidence of it, which I think is all of the relief you're entitled to.
Except getting it off his record is the other issue. That's the sticking point. Because every time he gets pulled over,
Does this get it off his record?
it does, yeah. So that's the issue. I know the police,
Like off of what record? Off of the state,
yes,
what is it called?
carry.
Well, yes. I mean, because we recently decided a case, Xerox X versus Yale Y, 102 Mass 699 on June 8th of this year, it says there's no mechanism for us to expunge a 209A from the state domestic violence record-keeping system. And it's, unless there's fraud on the court.
So I'm not aware of that case. I've spoken with clerks and others within the court system, and this is what I was told essentially. Otherwise, I wouldn't be here today, and I would.
There should be a reference on the carry that says vacated.
Right, there is not.
But I mean, there's no, it should be though. That's it was, right?
Well, yeah, I'm sorry. Once it,
Are you sure if you look at if you pop a border probation record and it shows all the criminal and then it has the restraining orders up top, it usually says vacated if it's been vacated.
it's going to say vacated, but there's two different issues.
You want to erase it completely.
I want it gone, right?
Yeah,
And
we can't-
if you're telling me that you've
That requires
decided.
expungement.
Right.
And I don't think we can do that.
And, right, if you told me you've decided that you can't do that, then you can't do that, apparently. But I think that should be the issue. I think that particularly when it's vacated, and, if the police have been notified to destroy all records pursuant to the statute, that means that the vacate order goes all the way back to the ex parte order. And if it goes all the way back to the ex parte order, then there should be no record of this happening. And
So you're saying that the judge should never have issued this 209A as to the extent that it involved the party's child?
No, both parties. For sure, under Smith versus Joyce, I think even the transcript reflects the judge agreed with me once he read the case with respect to the minor child, but.
What about her testimony that he said he was going to destroy my life and leave me with nothing, and her averment in her affidavit, I am afraid of him avenging himself since we filed the complaint? Why isn't that tantamount to an intimidation of a witness?
Yeah, well, there's two sort of pieces of evidence, right? There's the Fifth Amendment issue, which under McGinnis is not, it can't solely support a 209A. The comment, destroy your life, without more, remember, it's the plaintiff's burden. Destroy your life, and that's not all she says. She said, destroy your life and leave her with nothing.
But she said, I'm afraid of him avenging himself since we filed the complaint, and the judge credited that she was in fear and that this was a retaliation, that he said that in retaliation for her
Right.
having reported what she saw.
And I don't dispute that. the issue is the ambiguity in that statement. Destroy one's life can mean anything. It can mean destroy someone's financial life, destroy someone's, this is a
Would it mean killed their child?
It could mean that, but it's the plaintiff's burden to establish that that's what she meant. And in fact, she goes on, when I asked her, and I was very limited in my cross-examination of her, unfairly so, I think, which is a whole different issue that I didn't brief, and I'm entitled to cross. I wasn't really able to, but one of the few things I was able to ask her was what she meant by that. And she said, it's on page 9, I believe, of my brief, and how she responds, and of course it's in the...
Well, you asked her what she meant when she talked about their separation was going to destroy her life. So you're saying when she used the same phrase, destroy my life, with reference to what the defendant said to her just after she reported to the alleged victim's mother what she saw, the only interpretation that the judge could make for destroy my life is financial.
I think it's the plaintiff's burden, and I think once she defines what it is, that's correct. I mean, she specifically is asked what she means by that. And
When she said it.
Right.
But what about when the defendant said it, she says it put her in fear?
Fear of what? That's the issue. It needs to be an imminent harm of imminent physical harm. You know, if it's and in the context of what she said, leave me with nothing. It wasn't just in isolation that she said destroy my life. She said destroy my life and leave me with nothing. There's more of a financial overtone to that than there is anything. And we're talking about a nonviolent, no record. He's leaving, by the way. He's not coming back saying I'm going to destroy your life. He's leaving.
Could the judge infer that from her testimony that what she saw was a crime?
I think that the judge, by vacating rather than not continuing, didn't hold that anyway. And it is a crime. If you credit her testimony, it's indecent assault and battery, assuming it's actually not even indecent, because there was I had to correct the judge because he at some point said sex and there was no testimony. I don't know if you call it that, but her testimony was that she saw them kissing, I think, or something like that.
Would a 13-year-old consent to being romantically kissed?
No, it's assault. It's not indecent. It's assault and battery. Now, I'm thinking of the statute, and it's technically not indecent. It's just assault and battery. Not just. It's still a crime. Yeah. So, but I mean, that, the issue about the destroy my life, the court ultimately vacated it, and there's a distinction there. Instead of the court just saying, I'm not going to continue it because I don't believe she's any longer in fear.
So where the court ultimately vacated it, how can we say that the court was wrong to initially find, based on her testimony, that she was in reasonable fear?
I think the court specifically said it was wrong by vacating it.
Why was that not just, well, let me actually have a couple of questions on that. So, starting with the ex parte, the 10-day order.
Yep.
Are you contesting that, at least based on the affidavit and the brief testimony, that was insufficient as well? Or is it only once you clarify to the extent what destroy your life means through your cross-examination that the judge should have been clued into the fact that that wasn't enough?
I'm just pulling that affidavit up. If you just give me one moment. Right, that's not sufficient either. Correct.
Okay.
Right. No, I don't believe. Right.
And is it your position then that by vacating the order, the judges, was it the same judge who vacated it? I just don't recall. I know McGrath extended it.
Yeah, we're talking years now, I think. Yes, it was. Yes, it was.
Cunis.
Yeah, I think that's correct.
Yeah, it was the same.
So does a different judge vacating a restraining order then how do we take that to suggest that the initial judge was wrong? Isn't that our job up here? You seem to have conflicting positions between the two judges in the same district court.
It does, except that the plaintiff has the burden of proof.
But again, to the question of whether the subsequent vacating of an order means that the initial or any subsequent extension was not legally correct or factually correct, how do we arrive at that decision? Don't we have to, isn't that something for us to do if we get there based on the fact that we determine it's not moot?
So I think the whole nature of vacating orders means that the order was not initially correct. I mean, I think that's
According to a different judge than the judge who initially, who's at the same level, if you will, as the judge who initially issued it and extended it.
So I don't see it as judges vacating orders. I see it as the court vacating an order, and each one of those different judges are just an agent of the court. So that's how I view it. I don't see it as a judge vacating an order.
What page is Judge Kunis's ruling? I can't find it.
We don't have it. There's a on the record attached to the brief towards the end.
Okay.
Yep. Actually, wait, where is it? It's on. I've got it written here. Page 37 of the addendum.
Yeah.
And I'm
Okay.
looking wrong. At the bottom.
Yep.
I looked on the docket this morning.
Okay.
Yeah.
But we don't have any transcript of that hearing, so we don't know the reasons why Judge Kunis vacated the order?
This was due, I believe, before, no, I'm sorry. This was due almost exactly around the same time of that hearing, so it had just been vacated. And I'd already asked for extensions 100 times on this, so I didn't have time to wait for
This was due, meaning your brief?
The
in
brief
this
was
case.
due, so I couldn't,
So you filed a motion for findings and rulings based on the suggestion of the single justice, and were there ever any findings and rulings?
never acted on. I even requested.
Instead, so is it possible that Judge Kunis vacated the order because he didn't want to write findings and rulings?
No, we had a lengthy, so of course from memory, but the hearing before that justice was not a 5-minute hearing. It was lengthy. We discussed about all the way back to the ex parte. She was represented by counsel, and he, after having heard everything, one of the more significant issues was.
Can I ask, was that a motion, or was that just an extension date? Was that a natural extension date that then the judge heard from both parties represented by counsel and after hearing vacated the order?
I think so. It was a 6-month. Yeah, that was a 6-month. But now from memory, the issue was that at that point, I'd had long conversations with a detective who had been signed, who was considering prosecuting, which is why he took the Fifth Amendment to begin with. And I was able to report to the court that they were not bringing criminal charges, and that was significant to the court as well. No criminal charges have ever issued. It just didn't happen. I don't know what to say, but that, I don't know if you picked the theme up a little bit. This was right after, I think this was the first time I'd cross-examined in 2 years after COVID. But the defendant had just said prior to all of this being reported to the police and all of this happening, was that he was leaving, that after all these years, I think 7 or 8 years that they had been together, he was done with the relationship. He was going to leave. He was the sole earner of money in the family, and they're unmarried. And then all this stuff popped up.
So if it closed by asking us what you'd like us to do.
I think it would help to have an order that the restraining order all the way back to the ex parte was unlawful for both. If you could do that, that would be wonderful. And then I can try to take it up with Carrie to see if I can get it off.
Okay.
Okay,
Thank you very much.
thank you.
Well, case is submitted.
Appreciate it. Have a good afternoon.
You too. So our last case on for today is 22P979 Boylston CP LLC versus Worcester Sand and Gravel Company, Inc. We've been waiting a long time for this moment today.
We all have, last but not least, hopefully. Good afternoon. May it please the court. Attorney Isaac Perez for the plaintiff appellant, Boylston CP LLC. Judge Ricky Ardoni, the trial court judge, his decision in this case was a little bit unusual. If you look at his findings, in the first part of the findings, he clearly found all of the elements of a legally enforceable waiver by the corporation of that term in the notice of contract regarding ownership of the surplus materials in this particular piece of real estate, which was known as Compass Point. And he did so based on the testimony of the plaintiff's principal, in which he said that prior to buying the property out of bankruptcy, he was aware that the prior owner was taking surplus materials out despite the notice of contract, and that Worcester Sand and Gravel had waived that provision. So he went to the principal of Worcester Sand and Gravel, who he was,
Can I ask you, just not to be technical, but did Worcester Sand and Gravel actually waive it, or did they just not enforce it? I think there was a difference.
Well, they certainly didn't enforce it.
There was no formal discussion, to your knowledge, there's nothing in the record to suggest an oral or certainly a written agreement between Worcester Sand and Gravel and, I think it was Compass Point or...
Compass Realty.
Compass Realty, right,
on
that?
What the testimony was that Compass Realty was taking the gravel out, and Worcester Sand and Gravel allowed it, despite the notice of contract. So basically, Boylston went to the principal of Worcester Sand and Gravel, this Michael Trotto Sr., and said, look, we want the same deal. If we don't get the same deal, we're not going to purchase this thing out of bankruptcy. It's a deal breaker. So Mr. Trotto said, that's fine. He was somewhat reluctant. He didn't like having to do it, but one of the things that he complained about apparently was, well, the notice of contract is poorly drafted. I'm not sure if it's legally enforceable. My lawyer did a bad job. So go ahead, no problem. We waived it. And the judge, in fact, found that that was a knowing waiver, met all the elements, clear and unequivocal conduct, words. And most importantly, he said, the oral nature of it doesn't implicate the statute of frauds. So that's not a problem. It's legally enforceable, despite the fact that it's oral. And then he said that, Trotto Sr. had the apparent authority to bind the corporation. So once you have all of those findings, you have a legally enforceable waiver of this provision in the contract. But then the judge...
I'm sorry, there's no evidence, though, that the corporation ratified that or that anybody else in the corporation knew about that.
Correct, but I'll get to that later, because that's, I think, an issue as well. But what the judge did, he did a 180, and he said, well, even though there's apparent authority, it's not binding on the corporation. And the reason is that at some point after there was an accusation by the son, Trotto Jr., he came to the premises and he said, you're stealing my gravel or our gravel. Mr. Haynes, the principal of Boylston, said, well, wait a second, I have an agreement with your father. And then he went to the Trotto Sr. and asked him to reduce it to writing, apparently to end any kind of controversy about it.
Can I ask, correct me if I'm wrong, though, before that, though, Trotto Sr. was upset, and that's when they had this further conversation about, well, you can keep taking it off as long as you give us your business.
Yeah, well, that was the essence of the deal. There was, in effect, that was the deal, that yes, I'm not crazy about doing this, but okay, you can do it, but as a condition, what I want from you is you keep purchasing materials from my company, which there was testimony that they did.
So as I understood, there was an initial agreement, a conversation, and then subsequently, Toronto's senior is on the site a fair amount, and he's not happy about how they're trucking the stuff
No,
off.
that
Or was that with
wasn't-
the previous owner? Was that with the
No,
Compass?
that wasn't the testimony. The
Okay.
testimony was quite the
As I
contrary.
misunderstood
That Boylston's principal said, no, he would periodically come to the site, he would visit, and he was well aware that we were carting the stuff off, and he didn't object to it because we had this agreement regarding a waiver.
So when your client testified, as I understand it, that Toronto Senior was upset about how the previous owner was trucking the stuff off-site.
Well, not-
We
not
reached an
a-
agreement that we could move the materials off if we continue to buy the materials from Sand and Gravel. Is that the original
No.
conversation, or do you think?
No, he was upset at his lawyer because he said that the lawyer drafted the notice of contract, but he did so poorly, and that there was some question as to whether it could be enforced or not. So he said, you know what, I'm not crazy about doing this, but I'm going to do it.
Okay.
As long as you continue to buy gravel from me, we've got a deal. And in fact, for several months, apparently, there was no problem. My client.
And
my-
the deal is before your client purchases, does the foreclosure purchase,
Correct.
right?
Right.
Okay.
He discussed it, he did his due diligence, he found the notice of contract, he went, before purchasing the property out of bankruptcy from that Compass Realty, he discussed the issue with Toronto Senior, and they cut this deal in effect, then he buys the property, subject to this waiver, and in fact, they basically, through their conduct, affirm that there is a waiver because he says he sees me carting the stuff out. There's no objection. He doesn't sue me. He doesn't complain about it. He knows exactly what's going on. The problem arose in the spring of 2016 when the son came and said, "You're stealing our gravel." And I think when you look at all of the circumstances in this case, I think what happened was that the father was ill. It was gravely ill, very sick were some of the words that were used, in failing health. And probably the son was starting to stick his nose into the business, almost probably in it because the father was sick. And Mr. Haynes told him, look, I have an enforceable waiver with your father. He went to the father, and he said to him, let's reduce it to writing, eliminate any confusion. And this was the only testimony in this issue came from Mr. Haynes. There was no other testimony from anyone. He said to him, okay, he didn't say no. He did not object to it, and in fact, there was some other testimony. At some point, it was kind of helter-skelter, but he said he agreed to it.
But
Later on,
why isn't that a credibility issue for the?
What's that?
Why isn't that a credibility issue on which we should defer to the judge as the fact finder? He saw Mr. Haynes testify. Mr. Haynes said he never said no. Mr. Haynes tried to infer that it was because Mr. Trotto Sr. was on his deathbed, but this had been going on for some time, and it had never been reduced to writing.
Right, but there was no testimony from anyone, obviously. Trotto Sr. had passed away, and he couldn't testify that he refused to do it. The only testimony that you had was that he either agreed to it or did not object to it, but was very ill. From which the only inference I think you can make is that they failed to reduce it to writing because the man was ill, probably had other things to worry about besides this waiver, and it never was reduced to writing. But that's it. That's the only testimony there was. So I don't think you can reasonably conclude that Trotto Sr. refused, quote unquote, to reduce it to writing. And I think the thing that really undercuts the judge is the fact that the judge himself offered a reason why Trotto Sr. might have refused to reduce it to writing. There was no testimony from anyone as to what was going through Mr. Trotto Sr.'s mind.
Assume we take that part of it out. So in what the judge has is two guys who are in the business, who've known each other for 15 years, who have a friendly relationship, who seem to chat on the site when he comes around, and they have this arrangement. Why could the judge, why is there nothing from that, especially when it's referred to as a handshake deal, and it was an agreement that was just made between each other? Now, I know you say that was, he's a layperson who doesn't know, but if taken literally, why could the judge not take those words of Mr. Haynes literally and say, well, what I get from that is that these are two guys in the business and they had a handshake deal between the two of them, and he wasn't going to bind his company because who knows, if this guy goes belly up too, you know, I don't want that deal to pass on to the next guy.
But the problem with that is that these are two individuals that are part of a corporation. They're the principals of two companies. They're acting only in that capacity. Trotto
Is there any
Senior.
gray area at all in this relationship?
What's that?
No gray at all in this relationship between Trotto and Haynes,
You know,
Senior?
I don't think so. When
Okay.
you sign a contract as the president of the company, and the company owns the gravel, and you start negotiating as to waiving, money, a payment for that, you're negotiating on behalf of the
But
corporation.
your client's been around for a while, so when you sign the contract, and he's clearly got a lot of different jobs going, why don't you say, okay, let's get the old contract and strike that portion, put a line through it, because I'm not agreeing to that,
You know,
and then buying this piece of
If
property.
he was a lawyer, yeah. The problem is when you get these businessmen and these closely held corporations, sometimes they don't pay attention to the legal niceties, which they should. Certainly, if you or I were representing them, that's the first thing we tell them, just make sure you put it in writing because there's a written notice of contract. But that's not how they do it. And it was only when the son created the controversy that he went back and he said, he requested him to put it in writing. And again, there was just no evidence there that he actually refused to do it. There's just evidence that there was a failure to reduce it to writing, and the only inference that I see is that the man was ill.
Does it make a
He was too
difference
sick.
if it's a failure or a refusal? And even if it's a refusal,
Well, I don't, because I think Your Honor, if I ask you to do something and you say, no, I won't do that, that's a refusal. If I ask you to do something and you fail to do it, there could be a million different reasons why you failed to do it.
Right.
In this case, the only evidence there was on the record that he was dealing with a very sick man. He got a call from his lawyer who told him this guy's in failing health. To me, that's a signal that, you know what, he doesn't really care about this. He's dying, and that's why it never got done.
Can I ask your deed, Boylston's deed comes in, and I think it's Exhibit 15. I looked at it. There's no reference to the notice of contract in that deed. But the notice of contract is registered in the Registry of Deeds, right?
It is,
So,
yeah, right.
If there was no oral agreement, would their deed still be encumbered by the notice of contract?
Yes,
Okay.
yeah, it would.
That's helpful to
It's part
clarify.
it's part of the chain of title. Again, better practice would have been to put it in writing and record it. They don't act like that because they know each other. And again, the key is here that even after they reach the agreement, Boylston purchases the property, they're carting the stuff out, and the principal of the company is there watching it and doesn't object and doesn't sue. It was only after he passed away that the son, who took over the company along with the nephew, they filed the suit. And that's another thing the judge said, well, they didn't know about it. Well, of course they didn't know about it. When they testified, they said, the son said, I was like an errand boy. All I did was I was a mechanic and I picked up parts. I had nothing to do with these contracts. So he was not in a position to know. And then the nephew basically, again, disclaimed knowledge of any negotiations of the notices of contract. I don't know anything about it. So they were not in a position to know. If they were in a position to know and didn't know about it, that would be significant. But if you look at their testimony, they had no reason to know that this oral agreement existed.
Can I ask you two questions? One thing I just don't understand, what is Boylston CP in the business of? Are they a real estate developer, or are they a...
Real estate developer.
Okay.
Right.
And
But what they did with this excess gravel, surplus materials, they took it to other projects.
Okay.
So it's valuable to them.
But the handshake deal said they would be purchasing something from Worcester Sand and Gravel.
Yeah,
too.
Worcester Sand and Gravel sells stuff to them.
Sells
In other
what?
words, they purchase other gravel.
Other gravel.
Other materials from Worcester Sand and Gravel.
And so if the handshake deal is binding on WSG, it's binding on several companies that Haynes is the principal of too, right?
In theory, I would say yes. And the testimony from Haynes was that, yes, my companies continued to buy materials from Worcester Sand and Gravel in accordance with the agreement.
Okay, and I guess that would be a counterclaim for them if that part of the agreement wasn't being honored.
Say, I missed that sentence.
They'd have to counterclaim, I suppose, if that part of the agreement wasn't being honored. Except they denied there's any agreement, so, okay.
But again, there was testimony clearly, and he was found to be credible that, yeah, he did live up to the part. Boylston did live up to that part of that agreement. So that there was buying, that was the consideration going to Worcester Sand and Gravel for this waiver. And if there's nothing else, I'll
Okay.
rest on my briefs.
Thank you. We'll hear from Attorney Foley to end our day.
Say that again, sir?
It's not important.
Okay, sorry. Paul Foley, Your Honors, I rise today on behalf of the appellee, Worcester Sand and Gravel. I was the trial attorney, so if there are questions about how the trial proceeded, I'm happy to answer those. I'll just, in beginning, just refer to a case that we cited in our brief, which is Commercial Credit versus Stan Cross Buick. This is 343 Mass 622. I'm reading a quote from page 626 of that case. The defendants assert that Lloyd had apparent authority to sell the car is answered by the rule that a third party cannot set up an apparent authority unless he relied on it when he entered into the transaction. And also by the rule that a person who deals with an agent, not as an agent, but as a principal, cannot set up apparent authority which the agent may be said to have had. In the present case, there was no evidence and there was no finding by the court that Haynes relied upon the apparent authority of Mike Trotto Sr. acting on behalf of Worcester Sand and Gravel.
Isn't the evidence that they didn't go through, they went through the purchase and sale because of that representation? Isn't that the...
Yes, the distinction that I'm making, though, is that, and this is consistent with the judge's findings, is that the judge appears to have found that there was an agreement between Mike Trotto Sr. and Jim Haynes, and it was strictly an agreement between the two of them and not one that was binding upon Worcester Sand and Gravel. I think the distinction that I'm making is that, yes, there may have been reliance on that oral agreement between those two gentlemen, but that there was no finding that Haynes was relying upon the fact that Trotto Sr. was acting for Worcester Sand and Gravel. In fact, the finding appears to be just exactly to the contrary. So that's the first distinction that I would make, is that...
Isn't Trotto waiving the rights of Worcester Sand and Gravel?
No. I would say that Trotto is saying to Haynes, I, Mike Trotto Sr., will look the other way while you take off product. That's essentially what the court is finding here. And
so
yep.
what evidence supports that? Because I think it's pretty clear what the judge found. The question is whether it was clearly erroneous or whether there was some evidence to support that or those findings.
This is a little bit tortured, but I'm going to go through the portions of the testimony that I could sort of cull out wherein this discussion is put forth. And I'll just, in doing this, I'll preface it by saying that you will note that on every occasion when Mr. Haynes is testifying, he's talking about himself, Jim Haynes, and Mike Trotto Sr. He is never at any point in time talking about Worcester Sand and Gravel or Boylston CP.
But the gravel comes from Worcester. It's not like it's Mr. Haynes's personal gravel and Mr. Trotto Sr.'s personal gravel. They're speaking maybe individually with a handshake deal, but they're businessmen.
They are businessmen making a handshake deal, and I understand the court's frustration with how this is all playing out. But I'll point out the frustration is on two sides. First off, if you're saying that Mike Trotto Sr. was acting on behalf of Worcester Sand and Gravel, the same question goes for who was Jim Haynes acting for. Jim Haynes wants the court to believe that not only was he acting for Jim Haynes, he was acting for Boylston CP, he was acting for Craig LLC, he was acting for some LLC in Holden, he was acting for some LLC in Shrewsbury. Who are we talking about? I understand that this is a messy factual circumstance, but that mess is on both sides. But if the portions of the transcript that I pulled out are as follows. And I believe that each of these back and forths are between either myself and Mr. Haynes or my opposing counsel, Mr. Jubert, or Mr. Haynes. Question, did Mr. Trotto's conversation with you lead you to enter into the agreement and make the bid at foreclosure? Answer, yes. Question, and was it your understanding you could use the material from Compass Point at other locations that you owned while under other companies? Yes. Again, no reference to Worcester Sand and Gravel, just strictly a reference to a conversation with Mike Trotto Sr. And again, Compass Point is talking not about Compass Point, it's talking about a plethora of entities that are either unaffiliated or loosely affiliated to Jim Haynes.
Jim, what you just read, do you have a site?
I do. It's Appendix 1, page 50, starting at line 4.
So 50, starting line 4.
The next back and forth is at Appendix 1, page 66, line 25. Answer, I found out that he was ill, and I asked him if he would be willing to put our agreement in writing. Question, and from your understanding, what was that agreement? Answer, it was that I could use surplus materials at other sites. Again, strictly a reference to I or Mr. Trotto Sr., no reference to Worcester Sand and Gravel. Appendix 1, page 68, line 9. Mr. Haynes, was an agreement ever reached, a memorialized agreement? Answer, yes. Was one ever written and signed? Answer, no. Why was that? We both gave each other our words that we would follow through on our agreement. So again, he's obviously speaking very informally about an agreement between himself and Mike Trotto Sr. Appendix 4, page 97, line 12. So you fulfilled the agreement you had with Mr. Trotto Sr. That was, you were having your part of the bargain. Answer, that's correct. Again, references to an agreement with Mr. Trotto Sr. Appendix 4, page 108. Question, following up on my brother's last question, Mr. Haynes, why didn't agreement be reduced to writing? I'm reading that as the transcript came out. Was there a plan to get it into writing? Answer, we had talked about it, but it was just an agreement we had made between each other. That Appendix 4, page 108, to me, is all of the basis the judge needed to make the findings that he made. When we look at the findings, I'll grant that the first paragraph of those findings obviously opens the door to the appeal from my brother here, but if you look closely at those findings, the court does not find that there's an agreement that's binding upon Worcester Sand and Gravel. He also does not find, as I was alluding to in citing the commercial credit case, that Jim Haynes understood and relied upon the fact that Mike Trotto Sr. was acting for Worcester Sand and Gravel. And so to sort of contradict my brother's statement that all of the elements of waiver have been met, they haven't. And in particular, they haven't been met with respect to the issue of relying upon the apparent authority of somebody who you say is acting on behalf of another entity. And again, I'll just reiterate that Mr. Haynes also wants to have the benefit of this oral agreement, not only for himself, not only for Boylston CP, but for a plethora of unaffiliated entities. And I think that advocacy lends to my argument and also to the judge's findings.
I thought he bound those other entities as opposed to benefited them.
No, well, yes, both parts, Your Honor. I think based on the judge's findings, the bargain that would have been struck was that he was bound insofar as he would have to get his product from Worcester Sand and Gravel, and he was benefited insofar as now he could take whatever he got on site and ship it anywhere he wished. So there was both a benefit and a bargain. I will note, although it's not part of the record, that this notion that Worcester Sand and Gravel was benefited in any way from this additional oral agreement is it's hard for me to understand. So, and the second part, again, of the commercial credit case, and also by the rule that a person who deals with an agent not as an agent but as a principal cannot set up an apparent authority which the agent may be said to have had.
I tried to read that case with the car dealership and the Bailey and all that stuff, and boy, I had trouble making sense of it. But I mean, isn't it simpler to say that he was dealing with, that Haynes was dealing with Trotta not as a parent agent, but as the principal? I mean, and as the principal, he was buying against corporation, not as an agent at all. I mean,
Yeah, I want to agree, but not hurt myself in so
right.
doing. I want to say that this was just Jim Haynes and Mike Trotta Sr. talking about something and sort of agreeing that, Jim, go ahead, take a few things off, don't worry about it. I won't tell my folks on the other side.
do we know how much Boylston paid for the property? Is that in the record?
1.85 million, and I think that was in August of 2015. And I did want to point out.
That's in the record?
It should be, yeah. It would be part of the deed that you referenced.
Okay.
The foreclosure deed, which is Exhibit 15, I think. And that foreclosure deed does make reference to the notice of contract or any and all terms binding upon the parties at that point in time.
Ms. Foley, can I ask, you spent some time talking about the definition of refuse or refusal.
Yep.
Can you address Judge Massing's question? Is there really a difference whether it's a failure to reduce it to writing as opposed to a refusal to do so in the context of this particular case, or do you think there was a distinction?
I don't think that it's the principal issue. I think that the issue here is what happened between Mike Trotta Sr. and Jim Haynes when they initially came up with this side agreement. I think it's an issue that, if the court is to.
I mean, I guess what I'm saying is, if the question was the judge's finding clearly erroneous, can the judge infer that a failure is this, essentially crediting the testimony, that the failure is basically the same as a refusal in this context? I mean, I guess I'm having a hard time seeing the difference. I mean, they didn't write it down. He said, will you put it down into writing? And he never did. Okay. So why can't the judge infer that the failure to do that just means there wasn't a written agreement without having to require some affirmative refusal to do so, which I'm not sure is there?
The import of that circumstance to me, and I don't know if I'm answering your question, Your Honor, but the import of that circumstance to me is the timeline.
Okay.
When that request is made that Mike Trotta Sr. put it into writing, it's 6 months before he passed away. And that's part of the record.
Okay.
So it's not as if this is somebody on their deathbed, and there's certainly.
I sort of in my head had it that he was really sick. He got the
Where do
call
we-
and the communication. And
Where do we see in the record that it's 6 months before? Because I know in that transcript you were quoting, when was that roughly? It was when we had the first issue at Compass Point. Is that what you're saying was 6 months before?
Yeah, correct. So I think that the testimony was that sometime in the spring of 2016. Keep in mind that this case was filed in April of 2016. I think this case was filed in April of 2016. Mike Trotta Sr. doesn't pass away until December of 2016. So this entire issue bubbles up for certain in the spring of 2016. And it bubbles up as a result of a meeting on site where Mike Trotta Jr. sees Haynes taking truckloads off and says, hey, what are you doing? And then the testimony from, and I'm sorry, Your Honor, but I don't have the exact site as to where this appears in the record, but.
Talk to your father or something.
Yeah, so Mike Trotta Jr. says, hey, you shouldn't be doing this, and Haynes says that at that point in time, he went to Mike Trotta Sr. and asked him, hey, can we put this in writing?
you're saying this then 6 months before he dies?
6 months before he passes away. So, the question of refusal versus simply ignoring the request, to me, you're talking about a long period of conduct. The other import of that back and forth to me is just the fact that all of a sudden, 7 months after he purchases the property, or I'm sorry, 7 months might be too short, 9 months after he purchases the property, Haynes is requesting that Trotta Sr. put this into writing. To me, that's an admission by conduct that this was not binding on Worcester sand and gravel. The standard here is obviously that the findings of fact by the court would have to have been clearly erroneous. And I think based on the testimony that I've cited to the court, I think based on some of the other factoids in the record, that's not the case. That in fact, that the judge's findings were somewhat insightful in terms of the relationship and how this all played out. And that's how it played out. I have nothing further.
Well, thank you again. Today's been a really exceptional day in terms of briefing and oral argument. I want to, again, commend both of you on your briefs and arguments. And I noticed Tatiana Tway is on your brief. Is that the one who used to clerk here?
She is the one that
So
used to
make
clerk
sure
here.
that you tell Attorney Tway that the court was impressed with the briefs.
I will, Your Honor. And she is with the Patent Office now. She took a position with them, but I do correspond with her, and hopefully she's watching today. But I will pass that along, Your Honor.
All right. Well, thanks. So we'll take the case under advisement. I want to thank the court officers, the clerks, and we'll be in recess.